charged with especially aggravated kidnapping, you're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police, Verbal Latin.
Is that correct?
Oh, for crumb's sake. I didn't ask you to interrupt me.
Scratch all that. Oh, that was terrible. I apologize.
Alrighty. I think we have a mic now. We have cameras. It's dark as I'll get out in here. It's right there, but I'm huge. All right. We'll get everything fixed up here in a minute. It wouldn't be a Monday if it wasn't like this. So. Is that better? A little bit, tiny. All right, welcome to the Court of Public Opinion. I am the Recovery Addict. I should never change anything. I should never change anything right before the show. This is the lesson I need to learn, because now I have to sit instead of stand, just to make my camera work. Good morning, one and all. Good to have you here. Happy last Monday. Absolutely last Monday of 2024. Hope you're having an absolutely fabulous one. How was your weekend, everyone? How was your weekend? Was it good?
Have them send someone with more experience.
We could do that. But more experience costs money. We're short on that. There we go. Jamie, thank you very much for being first in chat. You're responsible for the internet. I think you were probably nervous this morning. I know I would be. If I were you, but let's see. Where's my? Oh, that's wrong. That's right. Okay. All right. Congratulations. Please seat us if you can. Take your seat. Please be seated. It's all good. We're still sitting at our standing desk. Yes, because I changed out my camera mount. See how it does that little funky angle? I thought it would be better to bring the camera closer to me. It's not, for the record.
Happy birthday. You look good.
It's not better, but thank you. Feels like a Monday. Let's see, how did it start? My daughter had oral surgery this morning. That went well. Although she doesn't, don't ask her about it. She's still under the sedation medication and everything. Even if you tell her her smile looks nice, it's a sad story. So don't tell her that. We've been demoing, found out I've replaced 2 joists in my bathroom, found out we need to probably replace a 3rd. So we're cutting the floor more, tearing more out. That's good. I've already been to Lowe's once, bought a new blade for my saw. That was nice. And I didn't realize how good a new blade could be, but I'm excited to have that. All right. Always happens when I'm first. Jamie, the internet is all yours. It was a crazy morning. This was on me though. This was not your fault. Please don't think it was by any means. What happened was I had a StreamYard as my last stream, and I set it up to mirror the last stream, but change the title, and so my switcher wouldn't push because the streaming key was different from StreamYard. It's different than from a switcher, and so I had to. I could go into StreamYard and stream, but it would create yet another key and open another one. So I'm like, let me just create a new one. And then when I did that, I actually found out that no, it wasn't the StreamYard key that was wrong. I had just forgot to check the go live automatically as soon as I say go live. It had like another layer. So I was live and it just wasn't working. I thought it was a stream key issue. Anyway, it was on my end, Jamie, so you're off the hook on that one. Welcome. Happy Monday. Tomorrow is our big end of year celebration. And here's what I have in mind. We're going to do a regular stream in the morning, and then we're going to do a special end of year, not really, I'm not saying a New Year's countdown, because most of us, let's admit it, most of us go to bed before midnight. We're going to do an end of year extravaganza where we share a lot of the best of the preceding year. And we're still working on putting that together, but I've got a lot of work ahead of me. We're going to be working on that this afternoon and tomorrow as well. So we'll do that. We'll do all that, and so we'll have a regular morning live stream. Then we'll probably take an early lunch. We'll have a break, and then afternoon we'll come back with the awards show, and we're just going to have some fun. So that's going to be good. All right, let's see. We have birthdays. We have to celebrate the birthdays. Do not forget that. Thank you very much, Sharon, for your help with this. Let's see. We have Eva Skybell. Let's do Eva. In Through the Outdoor, Jack Davenport, Rosie, who is 2. Congratulations, Rosie. Kate, True Crime Kitty, Emma, who is 1, and Anne-Marie S., all celebrating their special day. Let's sing to them. So wherever you are, stand up with me. I'm gonna have to sort of crouch, unless I can bring the desk back up. There we go. Slowly. There we go. All right. So we're gonna sing to Eva in Through the Outdoor, Jack Davenport, Rosie, Kate, True Crime Kitty, Emma, and Anne-Marie S. That's a 2-verser for sure. Everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. I think we're ready. Happy birthday to you. Happy birthday to you. Happy birthday. Through that for Jack Davenport and Rosie. Happy birthday to you. I only got to Rosie. I thought I'd at least get to Kate, but I struggled on Jack Davenport. Verse 2, we'll do a little better. We're going to sing to Kate, True Crime Kitty, Emma, and Anne-Marie S. Happy birthday to you. Happy birthday to you. Happy birthday, Kate, True Crime Kitty, Emma, and Anne-Marie S. Happy birthday to you. To everyone who is celebrating their birthday today, especially Eva, In Through the Outdoor, Jack Davenport, Rosie, Kate, True Crime Kitty, Emma, Anne-Marie S., and apparently one other. Let's see. Mark. We're going to add Mark. Here we go. Late edition. It's okay. I slept in too. It's like a cappella. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, late Mark. Happy birthday to you. Happy birthday, Mark. I'm sorry, you were late. It's okay. It's all right. Don't feel bad. It's your birthday. You're entitled to that. To everyone who's celebrating a birthday, thank you. I realize there are a million places you could be, a million people you could have chosen to celebrate with, but you've been here with us. The privilege and pleasure is ours. We're going to hopefully make your day a little more specialer. And you can start that by doing free pancakes at Denny's, IHOP Village Inn, McDonald's, Tammy Dunlap's house, Andy's Grill, and every other fine breakfast establishment that is worth their weight, their salt. What's that? Worth their weight in gold? No. If they're anybody and they do breakfast, they better give you free breakfast. Is this the drum solo? I think it's it. Ready? Beautiful. It sort of snuck up on me, sort of like the live stream this morning.
Happy birthday.
Happy birthday.
You look good.
You do. You look good. I need a little more color in there. Why do we not? Well, it is what it is. I'm excited. I'm past the point of no return on my bathroom remodel. I think during our live stream tonight, I might show you where we're at. But because it's going to be a sort of special thing and we might bring guests on, I'm not sure. Not tonight, but tomorrow night. Sorry. I'm going to use StreamYard and I'm going to connect via my phone and I'll just take you on a tour because it's literally 4 feet from me, and I can do that. I can just StreamYard in, and then I can give you a little bathroom tour, which will make you immediately. It will cure any of the problem you've had over the past years, thinking, "Oh, I'd like an old house. That would be so cool." No, it's not. It's not cool. It's not cool, and you don't want one. And I will cure you of that quite quickly. Let's see. Let me check chat here. Eileen Thurling, I just started my retirement countdown. 24th December 2025 is the big day, but my last working day will be the 19th of December. Eileen, that's exciting. So the last of everything is already happening. So that is really cool. Congratulations. We've got a couple membership messages to share, and oh my goodness, look at these. We have DSN, 24 months. Let me go big so I can see it over there. It says, thanks for my gifted membership. 22 months, DSN. Congratulations. DSN then promptly gifted 5 memberships. Thank you, DSN. We've got member. I don't know why I can't see this. Just someone has been a member for 11 months. Happy New Year. I guess they tried to change the name back, and they said, I guess anything is better than what I had, and they went with nothing. But that's good. Baby Bear, welcome to the jury. Baby Bear, thank you so much. Appreciate your support. Welcome. I love that Orange Courthouse. Kelly, member for 17 months, says happy holidays. Great to be here. Evangeline Light, 20 months. The only place I would want to hang out. Love this community and RA and his wonderful wife. I love her as well. Thank you. And you guys are not bad as well. You guys are not bad either. Chris Wallace, member for 17 months. Thank you. MCAT, member for 23 months. That's the big 2-3. These OGs are just incredible. Thank you. Tumwater Troy, member of the jury, 15 months. Ta-da! I heard the Windows sound when you said that, Tumwater Troy. I'm not sure if that was intentional, but ta-da! I heard that in my head. Cheryl Ann B, member for 15 months, says, hi, I've been offline since the 20th. I hope everyone had a Merry Christmas. Sometimes taking a break is just amazing. Miss McGuire, member for 11 months, Merry Christmas and Happy New Year to you as well. I hope you had a Merry Christmas. New Year is coming very quickly, and we're going to have a party right here, so you don't want to miss it. We're going to celebrate all the bests of over the preceding year and maybe a little beyond. But I'm excited. I'm really excited about that. Let's see. Good morning from Niagara Falls, Ontario, Canada. Happy almost New Year. You're on the uphill side, right? Happy anniversary to everyone who's celebrating. Thank you. I switched mics. Is that any better? Does it like visually? Now you can see everything. It's just this one just seemed to block. It was like, and I switched mid-song, if you noticed. That's how talented I am. Offline, what is that? This is me. Excuse me, I must go chase puppies. Well, that's what happens when you have puppies. No debt in retirement is also key, maybe more important than savings, though both is ideal. Yeah, that's the goal, right? We're all trying to get there. All right, we have a little bit of court happening. It's still sort of like the holiday week, so it's let's see, where'd to go? So this guy.
Strat,
I think it was this one.
what's your response, if any, to the motion?
Well, I contest it. For many different reasons, I still have not been able to get any of my property. The last order that you granted, I went out there as you said to do, and the pole barn was unlocked, so knocked on the door, nobody was there. I worked on the pole barn and getting everything as much as I could out of it, but it had been gone through and it looks like somebody just ransacked it and knocked all my stuff all over. There was stuff that was missing that I had no way to find out who took it, or because there's no way to talk to Mrs. Osborne. She's made that impossible. I cannot continue. I can't pay $2,200 a month for a house payment and child support and live on my own. There's just no physical way for me to do that. Being taken out of that environment, that was my work. That was where I lived. That was where I worked. So basically I was eradicated from that house with all of my stuff there. And I'm still trying to recover from that. Not being able to work for 60 days because Mrs. Osborne would not grant me right to my tools. It cut my head off. There's no way for me to make a living. I tried to find jobs, can't find one. So I'm still trying to go through that.
Okay.
Sorry, go ahead.
Okay, Ms. Osborne, what's your response? Or Miss Osborne.
He's muted.
You're muted, ma'am. You have to unmute.
Sorry about that, Your Honor.
Go ahead.
My response is that Mr. Osborne has been out several times, not only invited, but uninvited. He has been here to get his property over the last few months, so many times I can't even count.
Okay, well, what about the last? I don't care about all the other time. What about the last time?
The last time
previously ordered it.
He came out here at 1:30. I left the barn unlocked. He went in there to recover his items. He was here until December, until almost 3 a.m. when the police had to make him leave. And they had to make him leave because he decided to take a drill to the front door and drilled through the handle and the deadbolt, ruining the whole front door. So, which put me and my children in the hole for Christmas. We were unable to have a Christmas because I had to pay for that. Every time he comes out here, it's to harass me. I have given him everything and I can't take this anymore.
Okay.
He's just trying to find a way to hang on constantly. Nobody has taken his things. In fact, the trailer you told him to get, the steel concrete machine, everything's still here. He won't take it.
Okay. Well, what happens is the issues before the court for the entry of the judgment in the UCSO, court has not been apprised of any reason that the court shouldn't enter that. There may be issues that relate to enforcement for that, and that could be, again, subject to later petition if the parties wish to, again, dispute or contest that, that's fine. But for today's date is just whether we enter the judgment. Court does note that the court had previously had a trial on this matter, had ordered this, so there's no claim that it's not consistent with the court's ruling. The court will enter the order, the judgment of divorce in the UCSO as submitted in this case, and that will conclude the matter today. And you can proceed with other action if you wish to do so, if you have a basis to do so, by filing a motion to enforce the judgment. So,
okay, so that was not the one we needed. We wanted a different one. So give me just 1 second. That's somebody having a bad Monday, and it's terrible. Here we go. Minecraft Court is where we should be. Oh, look at the pretty sky. Looks nice. We're going to skip ahead because we can. This was this morning. This is what happened this morning anyway. Don't want to skip too far though. Well, I want to skip far enough though. Right there. All right, here we go. It ended. I'm not sure. It's a messy divorce, but this is our favorite Minecraft court. The part that's blocked and pixelated is where the jury sits. So if they are present during the video, they would look like Minecraft characters. Where'd it go? Serious? They're going to do this to us over and over? There we go. We're all back. Apparently it's cold in here. The court recorder is a little chilly. The cardigan is not enough. I think Steve's coming. Hi. Miss McGuire, welcome. This is this morning's court, but the screenshot they show is obviously not from that day, not from today.
How you doing in there? You holding up all right? You on the second floor?
Pardon me?
Are you on the second floor?
I'm on, fifth, I think.
Fifth?
I'm in B5.
Short Life Creations. Can't wait to spend 2025 with you guys. Wishing everyone health and happiness going forward. Thank you. You as well. Thank you. Thank you. Here comes Judge. Oh, I'm missing my lights on my desk. That's what it was.
Thank you, Your Honor. We're present in the matter of State of Ohio versus Mark Gaskins, case number 24-CR000976. The defendant is present in court with defense counsel John Fatika. On November 19th, 2024, a 3-count indictment was filed against the defendant, count 1, 2, and 3, all being gross sexual imposition, a felony of the 4th degree, in violation of revised code section 2907.
Josh, is this the right one?
1. Prior to coming into court today, the state did provide defense with the following plea offer, that the defendant plead guilty to count 1, and that the state would, at sentencing, move to dismiss the remaining counts. There would be no agreement as to sentencing at this time. All discovery has been provided to defense. Thank you.
Mr. Fatika.
Good morning, Your Honor. We are in receipt of the offer as well as discovery. We asked for a change of plea hearing on a jury trial day. Give me an opportunity to speak with Mr. Gaskins about what he'd like to do to resolve the case.
All right, Mr. Gaskins, do you understand what the offer is in this case?
Pardon me?
Do you understand what the offer is?
Yes.
All right, I'm going to set this case for a jury trial March 3rd at 8 a.m. We'll have another hearing that will take place on the 19th of February at 1:30 p.m. That's the chance you will have to either accept or reject that offer. Do you understand that?
Yeah, we're going to talk before that.
Pardon me?
We're going to talk before that, okay? Let the judge know you understand.
Okay. Yes.
All right, anything else, Mr. Ronick?
No, Your Honor. Thank you.
I don't think it's this one. I think it's the next one.
All right. I'll be over to talk to you, okay?
Okay.
Okay. It's after that guy. Our person with no name is Gillypud. Thank you. Welcome, Gillypud. Appreciate that. Kathy, member for 7 months. Happy New Year's Eve, y'all. It's New Year's Adam right now. It's New Year's Adam. Tomorrow's New Year's Eve, and then it's New Year's Day. Adam, Eve, Day. I think that's the order it goes. Kathy, hope you have a great New Year. Let's see. Give him a second to change out in court. Get the new people in. Still waiting. Hope I'm not missing it. Might have been a short one. Broken Baker raid. Hey, welcome all. Hey, Valhalla awaits. Good to have you here. All of you, Broken Baker. Good to be here. For those that are just popping in, tomorrow night we're doing a end of year celebration of some of the greats that happened in the world of true crime, live streaming court cases. Please do join us; it would be awesome. Chrissy Bacon, member for 16 months, still love this channel. You can't change it. I'm convinced. Where'd it go, Josh? I'm missing it. Oh, there we go. It was quite delayed. There we go. Oh, there's a good buzz there. That's pretty good. Is everyone feeling buzzed? Oh, sorry. That was not appropriate.
Your Honor, what do we have opening as well?
All right, you want to call your first witness?
Here we go.
Your Honor, we would call Scott Smith.
Scott Smith.
Your Honor, you have to have a separation witness. Yeah, thank you.
Yeah.
Sequestration order.
Those who are non-parties who are going to testify, you're going to have to go wait in the hallway till you're called, okay?
Mr. Smith, please stay, and Mr. Burris in the hall, please.
So we walk in right now. We have no clue what's happening in court. I can tell you there's no...
Will you raise your right hand, please?
There's no jurors.
Testimony about gives the truth, the whole truth, nothing but the truth, so help you God.
Seats are empty.
All right, have a seat right here. Make sure you speak into the microphone. Mr. Rendell?
Mr. Smith, can you please state your full name and spell your last name for the record?
Scott A. Smith.
Whoa.
S-M-I-T-H.
His mic's working.
And Mr. Smith, how are you employed?
I'm a land surveyor.
And
Oh,
what
they're the
kind
ones
of
that find the
training do you
bodies.
have as a land surveyor?
I did some college. I took a technical course, and I attend seminars.
And how long have you been employed as a land surveyor?
38 years.
And where are you currently employed?
Land Design Consultants, or LDC Inc.
Mr. Smith, are you familiar with the property located at 35951 Maple Grove Road, Willoughby Hills, Ohio?
Yes.
And how did you become familiar with that property?
I was contacted by the owner to do a boundary and topographic survey.
Nikki, you guys find all the crazy stuff, right? Doing the surveys of properties.
And what were you, is there anything in particular you were looking for when you were doing the survey?
I don't really understand that question.
Was there anything in particular that the owner had indicated that they were interested in you reviewing with this survey?
I still don't understand.
I'll try this. Are you familiar with the easement affecting that property?
Yes.
Was part of your survey to address whether or not that easement was accurate?
Yeah.
And who hired you to do that?
Well, I was hired by Pete Merrick to do the survey, and he provided me the easement.
Permission to approach, Your Honor?
I wonder why he's being a little belligerent, this witness.
I'm going to hand you the marked Plaintiff's Exhibit 1.
Okay.
Do you recognize Plaintiff's Exhibit 1?
Do I recognize it?
Yes.
Yeah, it's been a while since I looked at it, but
What is Plaintiff's Exhibit 1?
I'd have to review this.
You can't see me. I found a fix for this, and I don't like it. The fix is that I add a longer delay to my live stream. Instead of being almost instant, it gives YouTube better time to sort of crunch the video.
And what was the question?
For output.
What is that document?
It's an easement.
And what is an easement for?
There can be multiple reasons for an easement. Utility companies have easements. In this case, it was an easement to cover an encroachment.
How do you conduct a survey?
How do I conduct a survey?
Correct.
I don't think that's a quick, I don't think there's a quick answer for that.
He does not want to be
If
here.
I can try to give you a quick one, any survey that we start, you start with the county GIS department, then you go to the deeds, and there's a long chain after that, archive tax maps, multiple ways of doing research. We don't conduct a title search, but we encourage the client to provide us any easements.
Permission to approach, Your Honor?
That's fine. I like
just
this
approach
answer.
anytime you need to.
You could just approach whenever.
Plaintiff's Exhibit 2.
Okay.
Do you recognize Plaintiff's Exhibit 2?
Yes.
What is Plaintiff's Exhibit 2?
It's the boundary survey that I performed for them.
And approximately when did you perform that survey?
August 2nd, 2023.
And when were you contacted to do the survey?
I'd have to go back and look at the emails, but probably about a month or two before the product.
So you're about a
How
month
does your
out.
survey compare to the easement?
He's not going to answer this one.
I show the easement on the survey.
He doesn't like these questions.
Did you talk to anyone while you were performing the easement?
Performing the
Or,
easement?
sorry, performing the survey.
Yes, I did.
Who did you talk to?
I called my client immediately when I saw the encroachment. Also, the owner of the dwelling with the encroachment was out there at the time.
Ooh.
Did you talk to the owner of the dwelling?
Yes.
What did you say to the owner of the dwelling?
I said, I'm going to review everything with my bosses. We're going to double check and triple check everything, and then we'll return to stake the line. Not wanting to upset him, because I'm sure anybody would be really upset to see stakes coming right up to their garage.
Was there any encroachments indicated by your boundary survey?
Yeah.
And what are those encroachments?
Well, the garage is definitely encroaching.
By how far?
5 feet.
Is there any other encroachments indicated by your survey?
I thought there was, and it's not standing out here. Wrought iron fence? Yeah, 1 foot.
What was that?
There's a wrought iron fence on the western property line.
Is that the opposite side of the garage? The
Opposite
garage on the
side,
eastern?
yeah.
The garage is on the eastern side of the lot?
Correct.
All right.
At this point, I don't know if we have a
Are you sure
criminal
the garage is
matter
on the western side
or
of
a
the lot?
civil matter.
Eastern.
But we've got encroachments. An encroachment is where one person basically built on someone else's property or extended their own boundary to
Can you do me a
take
favor
some
and
of their
look at
neighbors.
the easement at the picture of the easement at the back of Exhibit 1?
Okay.
Look how many lawyers are
Which way
involved.
that easement is orientated?
There must be some money here.
It indicates that there's an easement over the existing driveway.
Do you see the N with the arrow that points that would indicate which way is north on this?
Yeah.
Okay. Would you agree with me looking at this that the garage is on the western side of the property?
I now have a water line break.
No, I don't agree.
4 feet from me. I'll be right back.
Permission to approach, Your Honor.
Just make sure you have this clear right north.
Okay, I'm sorry. The leak is done. We have a moment of silence. How did it end? How did it end? Was it terribly depressing and boring?
East, west. That's the garage right there.
Why did it stop? Did I stop it?
You're looking at,
Oh my goodness.
North that way.
yes, same way. North, south, east, west.
Right.
And there's the garage.
two different
He's saying the
surveys.
garage is on the eastern side.
You guys are looking at two different
I
properties.
know. Don't interrupt me.
There's the western side.
Don't interrupt me.
It's right here.
Now you can see too.
What's on the western side on his property?
Oh.
That's on, the encroachment's on the eastern. That's what I'm saying.
You guys, it is the most Monday of any Monday I've ever had. We had in your panic, I paused it. It ended paused.
Did you talk to the property
I had
owner
water
about the
spraying
encroachments?
down underneath my
Yes.
bathroom. We
What if
fixed
anything
it.
did the property owner tell you?
But
Excuse me?
What if anything did the property owner tell you
What did the property owner tell me?
about the encroachments?
There was nothing really told to me. I told him that there was an encroachment.
And he didn't respond at all?
I can't remember what discussions we had about it.
Are you talking about with Mr. Fleming, Mr. Grindel?
This would be Mr. Merrick.
All right, well, let's use names.
Okay. Did you talk to Mr. Merrick about the encroachment?
Yes.
And what, if anything, did Mr. Merrick say about the encroachment?
I don't recall exactly what he said or how he was going to handle it. He was obviously going to be a friendly neighbor because he just bought the lot and you don't want to cause trouble and probably resolve it some way.
And did you talk to the owner of the
did
property
miss
next
a
door,
thing.
Mr. Brothers?
Yes.
And what, if anything, did Mr. Brothers say about this?
He was shocked. He wanted me to verify that I was correct, and then I did.
When's the last time you talked to either Mr. Merrick or Mr. Brothers?
I think 2 days ago I talked to Mr. Merrick.
What was the context of that conversation?
I emailed him to say that I was served a subpoena.
Did he tell you anything back?
I can't remember if you emailed me back or called me saying that you're sorry I had to attend this.
Yep, I emailed back.
the guy's like, yep, I emailed back. The lawyer's like, don't talk.
When you came out to your survey, what was on this project? What was on the property you were surveying?
Vacant land.
And what was on the property next door?
Older dwelling with an attached garage that wouldn't be part of the original structure.
No further questions for this witness, Your Honor. Mr. Lucas?
Thank you, Your Honor. Mr. Smith, I want to ask you a few questions. I want to ask you some questions initially regarding the document captioned easement, which is in front of you. It was Plaintiff's Exhibit 1.
Okay.
All right. So that easement was recorded on June 3rd, 2021, correct?
Let's see if he's nice to this guy.
Yes.
In the upper, I'm sorry, in the upper right-hand corner.
I see it.
Yeah, I'm sorry. Then in the first paragraph, it's going from Eric Miller to Jason Brothers, correct?
Yes.
And then in enumerated paragraph 1, I'm sorry, enumerated paragraph 2, I beg your pardon. Would you read that, please?
Paragraph 2.
Yes. Yes,
This
sir.
easement is granted subject to the following covenants, terms.
No, I apologize. Enumerated paragraph 2. The number 2 is there.
Number 2.
Yeah, I apologize, Mr. Smith.
The grantee agrees that all work in connection with the maintenance, use, inspection, repair, or removal as necessary of said driveway shall be so conducted and performed as to avoid all unnecessary interference with the use of the grantor's property.
So enumerated paragraph 2, by its very verbiage, includes removal as necessary of the driveway, correct?
Yes.
Okay. Now,
He's more cooperative with this side.
I want you, there's a reference in the
Probably his
easement
customer.
to the legal description of the property, correct?
Okay,
So if you go to, if you look at the bottom, if you go to pages 4 and 5, if you would please.
yes,
Okay, so go to the 5th page for a moment. Now that obviously encompasses the legal description that's the subject of the easement, correct?
yes,
Okay. So the very last line on page 5 indicates the permanent parcel number, correct?
it does,
And for just, without having to read that entire document, it ends in 0240, correct?
correct,
Okay. So that easement obviously is relevant to that particular permanent parcel number, correct?
They're fighting over land, but the number of lawyers involved would indicate that this is probably a lot of money at stake.
and what's your question now?
Sure. So there's a permanent parcel number identified under that Exhibit A, correct?
Okay,
So if you go to the, let's go back to the easement, first page, right? And if that first paragraph, where it begins, "know all men by these present,"
okay,
it specifically says the property identified on Exhibit A, annexed and included within easement, correct?
okay,
So,
correct,
so in that regard, the permanent parcel number on the last page is what's related to Exhibit A, which is related to the easement, correct?
correct,
Okay. All right, now I'd like to go to Plaintiff's Exhibit 2, if I might. And this was a boundary and topographic survey that you completed, correct?
yes,
And this
There's a
was
lot of
completed,
money
I
in
think,
fighting
because
over land and
regarding,
water.
The request of Peter Merritt, correct?
yes,
And as I recall your testimony, it was because he wanted, in your opinion, to be a good neighbor.
Like
in
a
trying to
good
deal with
neighbor.
this potential problem of encroachment.
I'm sure they wanted to get along, yeah,
Okay. So in the upper left-hand corner, right in the, where it says prepared for Peter Merrick,
yes,
is not the permanent parcel number 0240?
it is,
And that's the same permanent parcel number that was on the easement, correct?
yes,
Okay. Now let's go down to the areas where it would be directly above where it says Maple Grove Road, 60 feet.
yes,
Which is the right-of-way,
yeah,
okay? So on the left, or I should say immediately if you went north on the document, 024 is the Merrick property, correct?
correct,
And then the property to the immediate right of that, as you look at it, is in the name of Jason Brothers, correct?
correct,
And that is an 0230 permanent parcel number, correct?
correct,
All right. So in looking at this diagram, on the Brothers property, there's a driveway that's part of the included, correct?
correct,
And that goes northward, almost exclusively on the property of Brothers under this particular document, correct?
correct,
And then, as it nears the top where the garage is, there's a little, not a little, a jog to the left, which you show, correct?
correct,
And that jog is the concrete pad, correct?
correct,
But that concrete pad is really, if you can answer this, it's more of a turnaround, correct?
I would call it a turnaround, yes,
Okay. It doesn't impede at all ingress and egress from the brothers' property and their home to Maple Grove Road, correct?
that's correct,
Okay. So there's an encroachment for that pad, and then as you continue northward from the pad that you locate, let me strike that and ask you a quick question. Do you know how the extent of that encroachment from the pad onto the property of the Merricks?
it's not labeled here,
Okay. All right, good. I just want to make sure I didn't miss that. All right, so going northward then, immediately to the north of that is the garage, correct?
correct,
And the garage is also encroaching on the Merrick property, right?
that's correct,
And again, those encroachments are on the 0240 permanent parcel number, correct?
One of the encroachments is, the driveway is, the garage is not.
Well, it looks like the garage, a small portion of it, as you look at the garage designation, to the left, it looks like it's encroaching on that property.
Okay, as intriguing as this is, we're going to bail.
Exhibit 2.
Exhibit
because
2.
The only people enjoying this are the lawyers, and they're making a lot of money on that. So let's see. Give me just a second. I'm sorry. I know you guys are like invested now, and you're like, well, whose property? Who wins? Who wins? We'll never know. We'll never know. Because Santa Claus is in court right now. 13th Judicial District, Kansas. Let's see. There we go. I don't know what he did. Obviously, it was a rough Christmas. But do you have an engagement meter? I imagine I probably do. Since no, it's good. It's good.
Happy birthday. You look good.
I see. We have counsel now. It is 10:10, so I'll put this docket back into.
This is live.
Call. Ready with State versus Tara Bales?
Yes, Your Honor.
Case number 24 TR 1854. Counsel to state their appearances, please.
Jerry Regier on behalf of the state, Your Honor.
Bales does appear via Zoom audio visual. Judge, in this case, we have requested certain plea negotiations from the state. The state is asking that there be additional time to review the case for purposes of that plea negotiation request. Because of that, we are asking the court to continue this case.
Mr. Regier?
I believe that is an accurate summation of the current state of the matter, Your Honor.
All right. I will grant the continuance to, let's see, that was March 10th at 9. Is that correct, Jen?
Yes.
All right. If we get too loaded up on that, please let me know, and an alternate date.
Happy birthday, Chelsea.
So it will be continued to
Sure
March the 10th at 9. Ms. Bales, it's important that you stay in contact with Mr. Patterson. Be sure he has a way of contacting you as well.
Yes, sir.
Very well. Anything further on this matter?
Your Honor, for purposes of the proposed continuance, which party is the court assessing this?
Both.
Does not compute.
Joint continuance. All right. Next case, State of Kansas versus Tanner Bunnell.
Yes,
I'm sorry. Am I allowed to leave?
Yes.
Okay, thank you.
Yeah, parties are free to go on that matter.
Where's Tanner?
All right. The counsel state their appearances, please.
Jerry Regier on behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Tanner Bunnell. Mr. Bunnell, can you turn on your camera and unmute, please?
And point it at your face.
Tanner Bunnell, turn on your camera. There you go.
Sure. All right, just trying to get the camera set up right now. Sorry.
Start video.
There we go.
Okay.
Where's he at?
Judge,
Oh,
this
top
is
middle.
one count of circumvention of ignition interlock. I can tell the court my client is going to enter a plea of no contest to that charge.
If you're ordered to have an interlock, you have to have one.
Any additional negotiations the court needs to be aware of?
Aaron, thank you very much.
Yeah, go ahead, Mr. Regier.
Your Honor, assuming that a no contest plea is appropriately entered in this case, pursuant to plea negotiations at the time of sentencing, the state would be recommending a $200 fine, court cost of $108. The state is prepared to defer to the court on the issue of attorney's fees. As count one in this case is charged as Class A misdemeanor, the state is recommending a 6-month underlying sentence with 12 months of non-reporting probation. It is the state's understanding that certain administrative penalties would also potentially apply in this matter upon conviction under KSA 81017. I'm assuming that, or rather, I believe counsel for the defense is in a better position to address those than I am. So,
Judge, Mr. Regier has stated the agreements correctly. I have discussed with Mr. Bunnell the administrative issue. Although he does have his ignition interlock in now, they'll probably start that time over once they get this conviction. But we'd ask the court to accept his no contest plea.
Okay. Counsel, that is a B misdemeanor, is that correct?
A misdemeanor, Judge.
Okay. Mr. Bunnell, have you heard what the attorneys have told me?
Yes, I have.
Mr. Bunnell, do you understand that with a no contest plea, you'd be waiving your right to a trial?
Yes, sir.
And you would be the protections that come with that, such as cross-examining state's witnesses, calling witnesses on your own behalf, that sort of thing, you'd be waiving those as well?
Yes, Your Honor.
And do you understand that while there's maybe recommendations to the court in regards to sentencing, those are recommendations only? The court would not be required to follow those. With an A misdemeanor, you could be sentenced up to a year in the county jail and a fine not to exceed $2,500.
I understand, Your Honor.
Has anybody forced or coerced you in some fashion to enter this plea?
No, Your Honor.
Are you under the influence of any medications or intoxicants? Anything that makes it difficult for you to make
Christmas
important
lights.
decisions?
No, I am not.
And a Harry Potter poster.
And
Santa Claus right above
at this time, your plea is no contest. Is that
Annie
correct?
has a warm Christmas
Yes, Your
sweater.
Honor.
And if you had enough time to speak with your attorney on this and enter this plea?
Yes, Your Honor.
Very well. Counsel, is there a stipulation of facts, or Mr. Regier can go ahead and recite what the factual basis would be?
Yes, Your Honor. The state's evidence would show if this case were to proceed to trial that pursuant to the ticket, a stop did occur on July 1st of 2024. The ticket appears to refer to a specific location near the Boulder Bluff area. The state's understanding is that is in Butler County, Kansas. The stop appears to involve a 2011 Chevy Malibu. Besides citing the defendant specifically for no interlock device when required, were this case to proceed to trial, the state's evidence would show that the defendant was not in compliance with the restriction, and the state does have a certified driving record, which the state is prepared to proffer to the court if the court is prepared to accept it.
Don is a bail bondsman, I think.
All right. When was he
Not
supposed
Santa
to
Claus.
have the interlock device?
Your Honor, the state's evidence would again proffer pursuant to the certified driving record. The defendant was required to have the device beginning in 2021.
Annie's almost doxing her work. She's got a badge on.
Very well. I do find that there is a factual basis that the
Christmas
plea is
sweater.
knowingly and voluntarily entered with the advice of good counsel. And I do find the defendant guilty as charged. I will hear if there's any additional statements at this time in regards to sentence. I'll hear them. Mr. Regier,
Nothing further from the state at this time, Your Honor.
Mr. Patterson,
Nothing further, Judge. We just ask court to adopt the recommendations of the parties.
Mr. Bunnell, is there any statement that you'd like to make before I pronounce sentence?
No, Your Honor.
Okay,
James
well,
is on a
I
smoke break.
am cognizant that there's a lot of technicalities in regards to the interlock device. I also am familiar with how what has to be on a person's record before that gets applied. Having that on since, not doing it since 2021 is somewhat concerning in regards to that.
I'm going to address that, Your Honor.
Quickly, May.
You said he didn't want to say
Yes, in 2019 was when I got stopped for it. Then they suspended it for a year, and then following that, I was supposed to have a year with the interlock. I was stationed in Washington State. I went through an agency there, and they did not report anything to the state. When I came back and the interlock was removed, I was told I was out of compliance. Driver Solutions suggested I get it reinstalled. After that ticket, ironically, was when I had it set up to get installed, and it's been installed for 3 months. Yes, 3 months. That's all the information I have as regards to that case.
All right. I am going to adopt the recommendations of council. I will impose a fine of $200. Court costs and attorney's fees are assessed to you. I am going to give you a controlling sentence of 6 months in the county jail. I will place you on probation. Are you serving actively at this time?
I am not currently active. I work at KDOC El Dorado facility.
All right. You'll need to be in compliance with your driving restrictions. You'll need to be sure that you're current on that. Make sure you've got that squared away. The main condition of your probation is not to violate the law, but you are also to be in compliance with this. How long is it going to take for you to get this paid for?
I would request just 30 days because 2 checks I can get it paid.
Okay.
Possibly 1, but I just want to, just for safe, 30 days would be the max I would ask for.
All right. I'm going to order that you have this paid in full within 60 days. That'll be a condition of your probation as well.
Yes, Your Honor.
If for some reason that's not paid, you probably need to be in contact with Mr. Patterson and see about addressing that with the court. Okay. Counsel, anything further?
Your Honor, if the court is ordering the defendant to non-reporting probation in this case, is the court setting a specific time frame for that probation?
Beginning today.
For how long, Your Honor?
6 months, as requested. Oh, I'm sorry. That was a 1-year request, wasn't it?
That was the state's understanding as contemplated by the plea agreement.
All right. Yeah. 1 year non-reporting probation, a 6-month controlling sentence.
Very good, Your Honor.
You'll get credit for any time that he served on this, if any.
Yes, Your Honor.
Anything further on this matter?
No, Your Honor.
No, Your Honor.
Very well. This matter is adjourned and the parties are free to go. Next would be State of Kansas versus Darwin Carballo Romano, 24 TR 1445. Counsel state their appearances, please.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Darwin Carbella Romero, who does appear personally via Zoom audio visual. Your Honor, would announce at this time Mr. Carbello Romero is going to enter a plea of guilty to driving while suspended second, and states agreed to dismiss the speeding charge. There are agreed recommendations at the time of sentencing.
All right. And what are those recommendations?
Your Honor, pursuant to plea negotiations, the state is prepared to recommend at the time of sentencing in exchange for a successful plea today, a $100 fine, $108 court costs, as well as defer to the court on the issue of attorney fees. As it is charged as a Class A driving while suspended for count 1, there is the statutory minimum of 5 days. In lieu of that, the state is prepared to agree to recommend 10 days house arrest. The state's understanding is that the conditions of such house arrest were not specifically discussed during the context of plea negotiations, so the state would defer to the court to make the appropriate findings. The state would further be recommending a 6-month underlying sentence with 12 months of reporting probation, subject to all standard conditions, including a $60 probation fee.
Mr. Patterson, is that your understanding of the agreement?
Yes, Your Honor.
Okay. Mr. Caballo Romero, have you heard what the attorneys have told me? You need to unmute, sir.
Sorry about that. Yes, I did hear what he said.
And is that correct? You're entering a plea of guilty to driving while suspended second offense, a Class A misdemeanor?
Yes, Your Honor.
Do you understand with a plea of guilty, you'd be waiving any right to trial?
Yes, Your Honor.
Have you had ample time to discuss this with your attorney?
Yeah, I did.
And has anybody forced or coerced you in some fashion to enter this plea?
No, Your Honor.
And are you under the influence of any medications or intoxicants, anything that makes it difficult for you to make sound judgments?
No, Your Honor.
Very well. I do accept your, and counsel, I don't have in front of me the date of the offense. Counsel or either counsel or the defendant can give me their factual basis for the plea, including the date.
Your Honor, as it is a guilty plea that's contemplated, the state would respectfully defer to the counsel for the defense on that issue.
Judge, we would stipulate to the affidavit in the case, as well as these facts contained within the NTA, that this was a ticket that was in Butler County, Kansas, and that he was driving at a time that he was suspended and had a previous conviction. Does stipulate the previous conviction in this case.
Very well. I do find there's a factual basis that the plea is knowingly and voluntarily entered with the advice of good counsel, and I do find the defendant guilty based upon that plea. Any additional statements from counsel in regards to sentencing recommendations?
Not at this time, Your Honor, if the court is finding that count 2 is being dismissed pursuant to plea negotiations.
All remaining counts are dismissed pursuant to the negotiations.
Thank you, Your Honor.
Nothing further, Judge.
Mr. Carballo Romero, any additional statements that you would like to make in regard for a pronounced sentence?
No, Your Honor.
All right. What's your status now in regards to your driving privileges?
It's still suspended.
All right. How long have you been suspended, roughly?
About 3 years.
Okay. What actions are you taking to get that taken care of?
And Judge, I can answer that. I have reviewed the driver's license status, and we've been reviewing that throughout the case. I can tell the court during the time this case has been going on, he has taken care of Sedgwick County District Court, paid them off, and taken care of that case. He still has Thomas County District Court and Wichita Municipal Court.
So the Wichita Municipal Court, I still have to go to court on the 21st of January for. And then the Thomas County one I can have paid off this week, as well as partially for Butler County, I can pay it off this week as well.
All right. These are all driving while suspended.
I don't know what the charges are in each of those cases, Judge. I just know that they're pending matters that he has not resolved.
The Thomas County one is for an unpaid ticket. And the Sedgwick County one is for driving on suspended.
All right.
All right.
Mr. Carballo, any additional statements you'd like to make?
No, Your Honor.
Where is it you're employed?
I'm currently unemployed right now.
How are you proposing you're going to pay for the house arrest and so forth?
I have money for it.
I don't think I'm the person to do it. Don't think so. We're both too serious.
Yeah, I'm not employed right now, but I've got money that I'm using for to pay stuff off. It's money that my family has gotten from land that's been sold, and part of it's mine.
All right, I'm going to sentence you. I will impose a $100 fine. I will impose a controlling sentence of 6 months in the county jail. I'm going to place you on probation for a period of 12 months. You are to serve 10 days of house arrest. That needs to be set up through court services. arrangements need to be made and started prior to
10 days house arrest sounds like a good vacation.
January 7th. That's next Tuesday. So you need to, following this hearing, you need to contact court services.
Okay.
That will be an electronically monitored house arrest with the standard conditions. How long is it going to take you to pay off this case, sir?
I'd say no more than a couple of weeks.
All right, I'm going to assess court costs and attorney's fees to you.
Okay.
I think Don is a bail bondsman or something.
Mr. Cavallo, it sounds like you,
I don't think he's a defendant.
by not taking care of these things and continuing to drive, you kind of dug yourself a pretty deep hole. Hopefully you're getting yourself out of that now.
That's what I'm trying to do now. I really don't. Jail time over.
I want to emphasize to you that with this type of history here, I haven't had a lot of success with other individuals. Seems like a lot of people that have done what you've done continue to, as far as not taking care of things, continue to do that. I'd strongly recommend that you don't treat this case as probation that same way, because you do have a 6-month sentence. I'm quite likely, if it comes for a motion to revoke based upon noncompliance, is just have you serve your time.
Right.
So if this will be a standard misdemeanor probation out of Butler County. You'll need to sign that contract. Following this hearing today, you need to contact court services and get set up on that. As far as the payment plan, I'm going to allow you to make a payment plan with your probation officer, but sooner is a lot better than later on getting those things taken care of. Any questions?
No, Your Honor.
Counsel, anything else that we need to address? If he has any jail credit coming to him on this case, it'll be applied to the case.
Nothing further from the Honor.
Judge, I just want to make sure he writes down the phone number for probation. Do you have a pen handy, Mr. Cabello?
Yes, sir. Just give me just 1 second. Okay.
316-322-4153 is probation. Make sure and call them after the hearing. Also, take this phone number down, 316-322-0021. That's electronic monitoring. Make sure and call them to get set up.
All right.
Thank you, Judge. Nothing further.
All right. With that, this matter is adjourned and the parties are free to go.
Hang on.
Next case is State of Kansas versus Joshua Cole, 24 TR 103. Counsel state their appearances, please.
We're going to jump to a different court. Hang on. I've never seen this one before. Give me just a second. Indulge me just a tiny bit if we can. It's the end of the year. Licking County Municipal Courtroom 3 live stream. Licking County Municipal Court. Where to go? Come on. Licking County Municipal Courtroom 3 live stream. Why is it not? How many times do I have to say it? Licking County Municipal Courtroom 3 live stream. There he is.
Correct, Your Honor.
Do they have Napoleon's picture on the back? Who is that? It's like.
All right, Mr. Prius, it'll be the sense of the court as follows. I'll suspend in its entirety a 30-day jail term, put you on probation for a year. Terms and conditions will include a requirement that you undergo a drug and alcohol assessment, follow up with any recommendations, if any. No drinking to excess, no use of illegal drugs, no abuse of prescription meds. You need to maintain suitable
no drinking
employment,
to
following the
excess.
other rules the probation department sets for you. Fines $375. Costs will be assessed. There'll be a 1-year suspension effective from the date of your citation back on October the 26th. You have served the hard time portion, and furthermore, I'm going to grant the application for unlimited privileges. On the Mark Lanes violation, it's a $25 fine. Do you have any questions today, Mr. Frias? We'll give you time to pay. You'll get the details in the clerk's office. Mr. Kalsarek, anything further?
What entry are you going to utilize to grant the unlimited privileges?
Look at the pictures on the
one
back
that's
there.
Generated by the probation
I see
department.
Washington, but
Any other questions?
No.
Anything else, Ms. Yeager?
who's the other dude?
All right, very well. You may go with the bailiff, and Mr. Kalsarek will be available shortly to answer any additional questions you might have.
Thank you.
Thank you. Joseph Blaylock.
When you get done down there, if you just hang out down there, I'll be back. I'll be down there just soon.
Got one wall that's got like everybody on it, like a billion pictures, but
Okay.
those old ones. Who is that?
Next is the Joseph Blaylock case. It's 24 TRC 06713, and that's you, sir?
That is.
Record should reflect that the defendant is in the courtroom with his counsel, Mr. Kalsarek. We have Ms. Yeager here substituting for Mr. King. We're here for the purpose of a change of plea. The defendant was charged, coincidentally, with operating a vehicle while impaired with a prohibited concentration of alcohol over a high-tier limit and a Mark Lanes violation. Is it true Mr. Blaylock's going to be changing his pleas from not guilty to guilty, Mr. Kalsarek?
Yes, sir.
And is that true, sir?
Yes,
And are you aware that you're not required to change your pleas?
I am.
Do you understand that you're presumed to be not guilty of the offenses until and unless the state of Ohio could meet its burden of proof beyond a reasonable doubt?
I do.
Are you aware that you have a right to a trial with a judge or a jury?
I am.
And did you also understand that at the trial you could both cross-examine your accusers as well as subpoena your own witnesses to compel their attendance at the trial?
I do.
You would have had a right to testify or not testify at the trial. Nobody could have prevented you from doing so or forced you to do so. And regardless, if you elected not to take the witness stand, could not have been held against you in any way. Do you realize that?
I do understand that.
Now, a plea of guilty is a complete admission of guilt. By tendering the plea, you relieve the state of any burden of proof because you've admitted that you did what they're saying you did, and you give up those rights we've just discussed. Are you aware of that?
I am aware of that.
All right. Now, if I accept your plea and enter convictions here, I'm only going to impose one conviction and sentence on the OVIs because you've been charged with being too impaired but also over the legal limit. State gets to pick. I have no idea how they're going to pick, but I'll go ahead and ask.
Per se, please.
So they're going to ask for the high tier, which means you're looking at up to 180 days jail on that one, up to a 3-year license suspension, and a maximum fine of $1,075. Understand?
I do.
At a minimum, the court's required to suspend your license for a year, impose a fine of $375, and send you to serve either 3 days in the county jail to, in the alternative, successfully complete a 3-day driver intervention program, or you are eligible to ask the court for unlimited privileges, which would remove the requirement of any actual jail time, absent a violation of the rules of having unlimited privileges. Understand?
I do.
All right. The Mark Lanes violation is a minor misdemeanor, and the maximum penalty is a $150 fine. Any questions there?
No, Your Honor.
Are you satisfied with the advice and representation that you received from Mr. Kalsarek?
I am.
Have you been subjected to any threats, promises, or other improper inducements to get you to do what you're doing here today?
I have not.
Are you under the influence of anything right now?
I am not.
And are you a citizen of the United States of America?
I am.
And I find that your pleas and waivers have been knowing, intelligent, and voluntary. I'll accept the same. I'll enter convictions on the impaired and the per se and the marked lanes. Mr. Kalsarek.
Your Honor, this is
You're in
a true
Kansas
first
last.
offense. My client was insured at the time of the incident. He is gainfully employed in a professional position. We do request unlimited privileges after conversating with my client and seeing his history. I don't think there'll be a problem with the unlimited privileges. Thank you, Your Honor.
All right, thank you. And Mr. Blaylock, you have a right to make a statement as well, but you don't have to. Anything you want to say here?
No, Your Honor.
All right. I didn't catch exactly what you said, Mr. Kalsarek. What's your client's occupation?
He's an attorney.
Oh, okay. I thought you said physician.
I said professional.
Okay, I thought you said physician. Ms. Yeager, anything on this one?
No, Your Honor.
Attorney with a DUI.
I mumble a little sometimes.
It's all right.
All the time.
I'm told that way.
What is your practice area, Mr. Blaylock?
Labor and employment litigation.
Management or labor?
Management.
As a former member of Local 284 of the International Brotherhood of Teamsters, Warehousemen, and Helpers of America, the court does offer to recuse itself.
So moved.
So moved.
All right.
Judge is like, hey, I did that. 7, look at that courthouse. Looks great. Looks great. This is our final color, right?
Okay.
Or is it turn purple after this? It's like a fuchsia. Pretty in pink.
Now, his ALS has expired, has it not? Because the citation was in August. Have you reinstated your license?
I have not.
Okay.
He rattled that off pretty quick. He's said that a time or two before.
Okay, on the marked lanes violations, a $25 fine. On the OVI, I'll suspend in its entirety a 30-day jail term, place the defendant on probation for a period of 1 year, and approve the application for unlimited privileges. You will be required to undergo a drug and alcohol assessment, follow up with any recommendations if any are made. If not, you don't. No excessive use of alcohol, any use of any illegal substances, or abuse of any prescription medication, maintain suitable employment, and follow any other rules the probation department sets. It's a $375 fine. Costs will be assessed. 1 year license suspension. The judgment entry is going to reflect that suspension starts today. However, it's also going to reflect that you're to receive the credit for the 90 days that you've already served, and you've already served the hard time as well. So,
looks good.
Mr. Calisaric will see you over the finish line with the application for unlimited privileges, and once that gets processed by the probation department and sent back up to me, I will go ahead and sign off on that. And I didn't say it during the colloquy, but you do understand that if you violate the terms and conditions of the unlimited privileges, that the court has no discretion and is required to impose the entire balance of the suspended sentence, right?
I do understand.
Okay, all right. So obviously, it goes without saying, be careful. Do you have any questions?
No, Your Honor.
Anything further, Mr. Calisaric?
Following up on the entry thing again, the reason I was asking this is because he has an appointment to get the interlock on. I assume it probably won't have the entry back by Thursday.
This Thursday?
Yeah.
I doubt it.
Okay.
Yeah,
I just,
unfortunately.
go
So you
ahead
may
and
want to
answer that.
reschedule that.
Yep, I just needed to know that.
Sure.
That's fine.
Anything else, Ms. Yeager?
There you go.
All right. Court stands in recess.
Thank you.
Thank you.
He literally stands in recess. That was pretty cool. A little Licking County Municipal Courtroom there. Nice. All right. Let's see. We have. We can go back to. Well, we don't want to go back to that court. We can go back to 13th Judicial. I just wanted to see that one because that's one I hadn't been to before. Licking County. At least maybe we have. It seems familiar now. Let's go back to Mr. Geer.
I'm going to give her the opportunity to be represented by counsel. Ms. Willett,
Hey, Karen, the channel officially 2016 was when I first created the name, but we've been a little over 2 years.
I'm going to set this matter on the trial docket for February 26th at 1:30. That's the bench trial docket. Ms. Willett, if you are going to apply for an attorney, you need to do so today.
Okay.
If you may or may, I don't know what your status is, you need to fill out that paperwork completely. You can get that at the clerk of the district court. I would suggest that you complete it prior to leaving the courthouse today. At that point, if you qualify for court-appointed counsel, you'll be advised to who that is. It'll be your responsibility to contact them and be ready to proceed on February 26th at 1:30. That is a bench trial docket. And the issue there will be in regards to should your diversion be revoked, and also for trial in the event that it is. So following this hearing, you need to do that. If you show up without any additional progress on this matter, it's going to still proceed. So it's to your advantage to get that taken care of. So February 26th at 1:30.
Just a little too slow for me.
That's for the motion to revoke and bench warrant. Excuse me, and bench trial.
Let's check in with 134 first, because he's going to still be talking here in a little bit. CTRM 134, 36th District Court. Man, I said it clearly. CTRM 134, 36th District Court.
Hi, what's your name? David McLeod. David Wilbur McLeod.
Thank you. This is case 24-061-247.
They make him
State of
stand?
Michigan versus David Wilbur McLeod. Counsel.
Standing for the people, Your Honor.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. McLeod. Mr. McLeod has been advised of his constitutional rights, waives formal reading, stands mute, and asks that a not guilty plea be entered on his behalf.
Thank you. Court will enter a not guilty plea on your client's behalf. As to bond.
We're going to ask for a $35,000 personal bond. We're going to also ask for a tether with home arrest. This incident occurred when police were called to a store, and the defendant was holding a box cutter type blade in his hand. Police came. He had left by that time. They looked at green light video, saw his identity. They saw him standing next door in a field. They went up to him. They told him to drop the box cutter. He pulled it out of his pocket and held it in his hand. They finally got him to drop it. And he he resisted arrest, Your Honor. They had taken to the ground to handcuff him. And in the vehicle, he was hitting things and the windows. He got a laceration on his head from that. But the complaining witness at the store said he's been a frequent visitor there. He saw the knife, but he didn't feel threatened. But he did say that the defendant makes threats toward the staff in the store when he's at the location. He also said something about not pressing charges at the incident. I'm not quite sure about that. But, Your Honor, the situation is, Your Honor, that the defendant's got 5 felony convictions. I'm sorry. He's on probation for 2 of them right now. 3-2-23, guilty to controlled substance possession, cocaine or heroin, less than 25 grams. 3-2-23 for police assaulting, resisting, obstructing. So he's on 2 years probation. So he's on probation by the time this incident occurred. He's also got convictions for an unarmed robbery, 8-19-10. Another 2 other controlled substance delivery cases as well on a domestic violence. So we're asking for a tether with Your Honor. We believe the defendant is a threat to the store that he apparently frequents, and that they had called the police on numerous times. Thank you.
Your Honor, we're asking for a personal bond in this matter. Mr. Ragnon spoke about the store and, threats made to the store and stuff like that. My client is only charged with resisting and obstructing. Mr. Ragnon also stated that for whatever reason, the store said they don't want to press charges or whatever, obviously, but there's no charges that have been issued against my client. So at this point, Your Honor, we're only here for the resisting and obstructing. The resisting and obstructing is that he was pulling his arms away from the officers. They then took him to the ground and handcuffed him. So he wasn't, I wouldn't say throwing punches or anything like that, Your Honor. And yes, he is currently on probation. What that tells us is that he does go to court. He does not have a KPS history that I'm aware of. Your Honor, he does also, he's supposed to be taking some medications and he hasn't been receiving them while he's been in custody. So at minimum, we're going to ask you to mark his biomedical. And Your Honor, another thing as well is his fiance has had a few brain surgeries, and he's one of her main helpers. So he really needs to get home to help her out as well. So Your Honor, we're asking for a personal bond in this matter with no tether, as he will show up to court.
Thank you. The allegations include a little bit more than just failing to fall. He almost got himself shot pulling that box cutter out. And he's lucky to be standing here, quite honestly. Sir, you need to stay away from whatever store or gas station that is on 2nd Avenue. While this case is pending, you're not to possess a firearm, a knife, a box cutter, or any other dangerous weapon. You're not to have any contact with the address on 2nd Avenue. Fine will be $5,000 personal. I'm not going to put a tether on him yet, but yeah, that'll be at $5,000 personal. Next court date, January 7th, probable cause conference, January 14th, preliminary exam, both in front of Judge Giles. Thank you, sir. You can step aside.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. Marable, how can I help you?
Good morning, Yana. I'm here for Albert Jackson. Albert.
Albert Jackson. He is not
Albert Jackson,
not on the morning docket. So if you want to check back in the afternoon, that'd be great.
Thank you, Yana. Bye-bye.
Thank you.
She gone.
All right, sir. What's your name, please?
Nikita Terrence Wright.
Oh.
Number 6.
Oh, I see. Okay, this will be case 24045541, State of Michigan versus Nikita Trance Wright. Counsel.
Your Honor, this is a Stafford Jones case. Does Your Honor have authority to change her bonds or no?
Ooh, subject matter jurisdiction out of the gate.
Misdemeanor. Is there some? She said we can't change our bonds, or what?
Your Honor, I don't know. I just wanted to check and make sure because I know two of the judges you can change them. I just wanted to make sure before I put my appearance. So if the court is not aware of not being able to change it, then Jennifer Douglas for the people, P72748.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Wright. Mr. Wright has been advised of his constitutional rights, waives formal reading, stands mute, and asks that a not guilty plea be entered on his behalf.
I like her cadence. It's
Well,
just
we'll
great.
enter not guilty plea on your client's behalf.
And she's got a Zoom background with the succulents, too.
$1,500 cash surety capious in the file. As to my authority to change it, I'm unsure of that. I think I can change any of the misdemeanor judges' capiouses, but I'll have to inquire about that after we
change it.
But for right now, I will proceed as though I can change it. So arguments as to bond.
Your Honor, on Mr. Wright, the people wouldn't object to a personal if there was a tether. This is the second failure to appear. There's a previous failure to appear September 25th of 24. Then the arraignment on the bench warrant was December 4th of 24. So a little over 2 months had passed. And then, Your Honor, the very next court date was the pretrial for December 13th. And then that was the next failure to appear. So, Your Honor, it would seem that there is a risk of flight here that's been well demonstrated. So, Your Honor, I wouldn't object to a reduction in the money bond if there was a tether.
And Your Honor, I did confirm with my office. Judge Jones did give permission to Your Honor to be able to change those capious bonds. So we're also asking for it to be reduced down to a personal bond. Mr. Wright on the 13th he was zoomed in, but no one responded to him. But he said he will come in person going forward to make sure that there's no other issues. So, Your Honor, we're asking for a personal bond in this matter. And he does work, Your Honor.
Do you have somewhere else to live?
Your Honor, let me see. Trying to figure it out.
Yes, Your Honor.
Yes, Your Honor. He does. He resides at a different, or he can reside. He has a different address he resides at currently.
Okay.
I just wanted to double check the addresses that we have. So, but yes, they're different addresses where he's staying at this time.
All right. Here's what we'll do. Sir, while this case is pending, you have no contact with Ms. Gore, no contact with the Winston Street address. Is that clear?
Yes, sir. Yes, Your Honor.
There will, for the time being, be a GPS tether. It will be unrestricted as to time and place, so you can conduct your life as normal, and perhaps Judge Jones will remove that tether when you show up to your next hearing. Bond will be $5,000 personal. Next court date is January 13 for pretrial in front of Judge Jones. Thank you, sir.
Thank you, Your Honor. And just
Thank
for the
you.
record, the city does represent the people in Judge Jones's courtroom. I just didn't want to make an argument here if that's not what I was supposed to be doing.
January 13th. So,
This guy gets a blanket and a bag of ice.
Hi, what's your name?
Hi, I'm Demando Anderson.
Thank you, sir. I'll be right with you.
Or is that a kimono? I can't tell. Let's check in with Judge Mott, because this judge is a little bit slower this morning. I'm up for something a little faster pace, that's all. William R. Mott, Chief Judge, 30 JD. There we go.
Well,
If you can, sorry.
New Year.
Yeah. All right. I'll order the sheriff's department to notify Utah as soon as you get back to your.
No, what just happened? Did we miss it? What did the judge just do? I just missed it. He just went. Is this out of Utah?
All right, matter of the extradition of Michael Dana Ashburn. Mr. Ashburn, there's been a demand made for your surrender out of Utah.
Oh, Utah wants him.
Utah County, Utah, number 985915653, out of that jurisdiction. You're wanted for possession of controlled substance, third-degree felony, driving with measured controlled substance, Class B misdemeanor, use or possession of drug paraphernalia, and seatbelt violation. You have the right to challenge extradition and have an attorney help you with that here in Kansas if you wish. You also can waive extradition and go back and face the allegations in Utah. With all of your rights in mind, did you want to waive extradition or do you want to challenge it?
No, I just want to wait and get it over with.
All righty. Go ahead and sign that. I know you've signed it before, but apparently they gave the judge the wrong name a couple days.
You could just let me go, Judge.
It doesn't work that way.
Judge,
Yeah, I know.
I could be on the run. I'll never be a problem again. No one will catch me. I promise.
There's three of them, right?
Yes.
Okay, if that's all he's
There you
got.
go, Judge.
All right. Thanks. You have a good Christmas.
Enjoy
Well,
Utah.
If you can. Sorry.
New Year.
All right. I'll order the sheriff's department to notify Utah as soon as you get back to your.
The judge just stepped in it. He's like, hey, have a good Christmas season. And he's like, well, I'll be transported to Utah for my Christmas season to face some charges there. Magistrate, Lubbock County.
Crime. You understand that?
Yes, ma'am.
So in the case ending in 2139, you are charged with a Class B theft committed back on May 27th of 2024. And how do you plead to that charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of that offense. I'm also going to follow the agreement that you've made in that case, and I will now assess your punishment at 111 days in the Lubbock County Detention Center with your court costs of $280. You are going to receive all of the jail credit that you have in this case towards your sentence. That is showing to be 111 days from September the 11th of 2024 to the present time. And does that sound like your correct actual days on this case?
Yes, ma'am.
Now, any sentence that you receive today shall run concurrent with any other as permitted by law. Your jail time and your court costs in any of your cases today are also going to run concurrent with each other as permitted by law. So you are getting jail credit towards any court costs that you're owing. And then you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. So having said all that, that makes that particular case a time served matter. Was that your understanding?
Yes, ma'am.
Now we're going to move to the case ending in 2666, where in count 1, you're charged with a Class A misdemeanor offense of evading arrest or detention committed back on September 11th of 2024. And how do you plead to count 1?
Guilty.
I will accept your plea of guilty and find that you are guilty of count 1. And count 2 of that same case, you're charged with a Class A misdemeanor offense of resisting arrest, search, or transport committed back on September the 11th of 2024. And how do you plead to the charge in count 2?
Guilty.
I will accept your plea of guilty on count 2 and find that you are guilty of count 2 as well. And having found that you are guilty of both count 1 and count 2 in this case, I will sentence you according to the agreement that you've made on both counts to 111 days in the Lubbock County Detention Center, with your court costs in count 1 only of $280. Again, you're going to receive all of the jail credit that you have in your cases towards your sentence. The jail credit on this case is also showing to be 111 days from September 11th, 2024 to the present time. And does that sound correct to you on this case as well?
Yes, Your Honor.
So again, this matter is showing to be time served. Was that your understanding?
Yes, ma'am.
And Mr. Moore, does this resolve everything that Mr. Trevino has pending here at this time other than his parole violation hold?
Other than parole violation hold, Judge, and I'd like to put a few things on the record with that.
All right, go ahead.
Okay. Andrew, we have discussed the fact that you have a current parole hold in violation. Is that correct?
Yes, sir.
Okay. And you understand that the consequences of this plea and how that could negatively impact your parole status?
Yes, sir.
And you still want to go forward with this plea, right?
Yes, sir.
Okay. I have nothing further, Judge.
All right. And Ms. Soto, is there anything further from the state?
Nothing further, Judge.
Anything else, Mr. Moore, in this case?
No, Your Honor.
All right, then we will be adjourned in this matter. Mr. Trevino, you're adjourned from the courtroom. And Mr. Moore, you're adjourned unless you need something else from the court.
No, Your Honor. Thank you.
Thank you. And then Ms. Walcott, are you ready on your case?
Yes, Your Honor.
Okay, so April Presenia, if you'll come forward. Your client was in the courtroom and was placed under oath and did all the admonishments with us earlier.
I was kind of listening to it while I was doing mediation. I had my cell phone and computer.
Okay, great.
She wasn't supposed to show up. They told me it was canceled, and then they were calling me going, never mind, she showed up. So.
Oh, no. Well, sorry for all the misconfusion, but Ms. Pesina, you are here at this time for a plea in your case. And we're handling it over this Zoom proceeding. Is that all right with you for us to handle your plea this morning over this Zoom?
Yes, ma'am.
Okay. Some fingerprints were taken from you there at the facility for us to use as your signature on your paperwork today. Is that all right with you for us to use your fingerprints that way?
Yes, ma'am.
And have you been able to go over all of your paperwork prior to court with your attorney, Ms. Walcott?
Yes, but I was asking you, can I ask a question?
Yeah, do you need another question?
So is this criminal trespass? Because I'm in here for criminal trespass. I'm not in here for burglary. Burglary for my audition was last time.
No, that was last time. Yeah, this is the criminal trespass, and it's the time served.
Okay.
Okay, so I'm gonna have to interject because my paperwork says burglary of a vehicle.
Oh.
But so let's check on that.
I might have just been wrong.
Ms. Pesina, hold on just a second. I want to clarify and make sure you know which charge it is. And I'm double checking what it's showing in the computer at the jail too.
Go back to the offer. We switched a little bit.
I'm just going to have to interject because you're wrong.
And then we'll answer your question, Ms. Pesina. And then if you need more time to speak to your attorney after we make this confirmation, I can give you that time to talk to her, okay?
Oh, yeah. And yes. Right. Okay. No, we have the criminal mischief on there too. I was thinking criminal mischief, criminal trespass, but it's the burglary of the vehicle and criminal mischief.
It looks like the criminal trespass charge was rejected from September 6th of 2024. And so at this time, the only hold you have on you there at the facility, Miss Piscina, is the burglary of a vehicle charge. And that's what they're asking for you to plead to today.
Okay, yes, ma'am.
Do you need to speak to Miss Walcott anymore about that, or do you understand?
I understand.
Okay, and that's what the paperwork reflected, and you did have the other charge, but it was rejected.
What does rejected mean?
It means they are not going to file that charge against you, and the prosecutor, the district attorney's office decided to proceed on the burglary charge. And so that criminal trespass is basically dismissed and won't be filed against you as part of this plea agreement.
Okay.
But it's still just the misdemeanor and it's still the time served, like we talked about.
Okay. So, I think I talked about fingerprints. So in this case, Ms. Vicenia, in the county court 2024 criminal case 2215, you're charged with the Class A burglary of a vehicle committed on or about July 30th of 2024. And do you understand the full range of punishment that you're facing on this matter?
Yes, ma'am.
Okay. There was a plea offer that was made to you, and other than the offer, has anybody promised you anything in order for you to enter any type of plea today?
No, ma'am.
And Ms. Walcott, do you feel like that Ms. Piscina understands her rights and the proceedings as well as her charges?
Yes, Your Honor.
All right, then Ms. Piscina, in this case, ending in 2215, you're charged with a Class A misdemeanor offense of burglary of a vehicle committed back on July 30th of 2024. And how do you plead to this charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you have made today, and I will now assess your punishment at 116 days in the Lubbock County Detention Center with your court costs of $325.
116.
You are going to receive all of the jail credit you have in your case towards your sentence. That is showing to be a total of 116 days
So no time
from
to
September
serve.
6th of 2024 to the present time. And does that sound like your correct actual days?
Yes, ma'am.
Okay. Now your jail time and your court costs are running concurrent with each other as permitted by law. So you are getting jail credit towards those court costs that you're owing, and you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. So having said all that, that makes this a time served matter. Was that your understanding, ma'am?
Yes,
So
ma'am.
she's set free after
And
this.
does this resolve everything that Ms. Piscina has pending at this time to your knowledge, Ms. Walcott?
It does, Your Honor. I was just going back because we had 3 earlier in July that hadn't been resolved, and then the one in September, but it looks like we're resolving the July and everything else has been rejected. So I don't
You know what
see.
would be really cool?
That's what I'm seeing on my side as well.
If,
All right.
if Miss
So yeah,
Walcott
that should resolve everything, Judge.
was
Okay.
actually
And Ms.
in that
Soto,
room
is there anything further from the state?
and it wasn't a green
No,
screen.
Your Honor.
All right,
That's
then
like
Ms.
her house.
Piscina, jail staff is going to get you released later today once they're able to process my paperwork from this morning, and you're adjourned from the courtroom. Thank you for your attention.
Thank you. Happy New Year.
Thank you, you too.
Happy New Year.
And Ms. Walcott, you're adjourned unless you need something else from the court.
Miss Walcott, you can go back to tending your
Thank you. And Ms.
plants.
Soto, you're
Looks good.
adjourned unless you need something else from the court.
Thank you, Judge.
Judge, you're adjourned as well. Thank you. We're going to jump back up to another one of our favorites. We're going to Thurston County District Court 3. We're going to back up just a tiny bit to see what's happened here because we're a couple minutes behind. There we go. This is not a Zoom background.
So
Hang on just a second.
Sorry, I was muted.
Okay, no, that's all right.
I like the curtain. Or is that a Is that a screen? I think it's a curtain.
So, this is the anti-harassment calendar, and then I'm going to take attendance, find out who's here, first of all.
I'm here,
And
Judge.
so, in the back there.
Morning, Honor.
Yeah, hi there.
Counsel Adam
Hey.
for petitioner
Michaela, Michael. And then, you're Ms. Wright Van Meter? Okay. And then on the Zoom call, we have, said Alexandra Asbury.
Yes.
And so were you able to get service on Mr. Desmond there? It didn't look like he'd been served.
I do not have reliable transportation. I'm in a wheelchair and
Okay.
he lives in Shoreline. And I wouldn't be able to access his residence due to the fact that it's not wheelchair accessible.
Okay, no, but you can't serve him. You need to get someone to serve him.
Oh, okay. Can you
You
clarify?
can hire a
that?
process server, you can contact law enforcement as to where he lives or what have you, but he needs to be served. In fact, you're someone who can do it. That needs to be done by somebody else.
Okay, that was my very, very first question when I was looking
All right.
over all of this. And
All
then
right, so hang on just a second.
Okay.
Was it temporary? So what's going to happen today, ma'am, is a temporary was entered. We're going to reset this for 2 weeks from today to give you a chance to get him served.
Okay.
And a copy of this will get emailed to you. And be January 13th, 2025.
Okay. I know that the police department has contacted him and we're regarding another situation that was related to this. And he was not at his residence, and DSHS has also shown up at his residence. So I'm concerned he may have left.
Well, that's a possibility. It's also been my experience that, sometimes people try and go great lengths to avoid service. And so, but, I can't do anything in this case until he's been served.
I understand. So can you just reiterate for me? Probably, recontact the Montlake Terrace Police Department and see if they can go over. And then the other thing would be to actually hire somebody. How does that process work?
Yeah, that's up to you. There are people who do this for a living. I've always thought it's kind of an unusual way to make a living. And I used to say you can look in the yellow pages for process servers, but no one has yellow pages anymore.
Like John
but you could
Breaks
probably
Bad
just find
News,
online
but
a
legally.
process server and do that. And yes, some law enforcement agencies do provide this service. And, I can't really give you any advice beyond that.
Okay.
Other than to tell you, you can't be the one who actually serves him.
Well, that's a good thing.
And so we'll see you back here then on January 13th at 9 a.m.
9 a.m. All right. Thank you, Your Honor. I appreciate it. Happy holidays.
Thank you. You're free to go.
Jason's calling
And
in
then,
from his
let's see,
ice
who else?
fishing
We have
shanty.
Jason Workman. I see is present. And then is there a Sandra Ziotti who's not here? And then Alicia, is that Alicia Ramirez?
Yes, Your Honor.
Okay. And then it looks like Mr. Basanko's here also.
Yes, Your Honor.
Okay. And so both parties are present on there. Mr. Workman's here, but Ms. Ziotti is not. I think that's about it. So I'm gonna have the service conversation with you as well. I didn't see that there was any service in the file. Were you able to get Ms. Little served?
No, Your Honor, I spoke with the sheriff's department this morning and they did unsuccessful.
Okay. So do you want to just do the same thing we just did there? We just renew it and then. Okay. We'll stand by for a minute. And then,
Then I'm what?
what'd you say? This was just a notice of hearing. Okay.
We'll see at KQD.
So apparently there wasn't a temporary order entered in this case, so it'll just be a notice of hearing.
Yes, Your Honor, she did request a temporary protection order, but it doesn't look like that.
Right. And that was, I don't think that was me.
$80. What's the $80 for? That's crazy. That's a lot of money.
Just a second.
I think they should do it for cost. $80 is gouging people. I mean, unless you've got like a 1 hour drive to get to the property or something.
Yeah, that was. So if you want to come on up, we'll give you the new notice of hearing. And does he need another service pack or do they have that?
Yeah, they would need to come up.
Okay, you can take that and go over to the civil department. They'll give you a service packet.
Thank you.
All right. And we'll see you in 2 weeks. So Ms. Wright Van Meter, I see Ms. Ollinghouse is not here. And then she has been served. You're welcome. So it's about 9:10.
She was in the road walking around when I left for work.
We're about 5 minutes
She
behind.
was? Okay.
Mr. Workman has some fishing to do, I think.
Since she's been served, is anything improved out there?
So it actually did quiet her down for a little bit, but we haven't gone outside and I stay away from my front windows.
Right.
But she was out there yesterday yelling a little bit. I mean, it was every day.
No, I saw your video. So, well, we'll give her a little bit more time. It's now 9:10, and then I'm gonna have another, at least one hearing here. And then I'll just check back in with you. And if she doesn't appear by a certain time, then we'll just enter a default order and then we'll go from there. All right. So just stand by for a bit. So Ms. Ramirez, can you come on the Zoom call, please? Mr. Basenko?
Yes, Your Honor. Yes, Your Honor, I'm here.
Okay, so actually, before we do that, I want to speak with Mr. Workman. Mr. Workman, you're here. There was a motion to renew an order that's already in place. The petitioner is not here. So we're going to give her a little bit more time to show up here also. Were you served with this? You're muted. You need to unmute.
Can you hear me, Your Honor?
I'm not talking about you, Ms. Ramirez. I'm talking about Mr. Workman. So just stand by. Come back in a minute.
Can you hear me?
Yes, I can.
Okay. Yeah, I moved.
He's really close.
So, I want you to back away from the camera a little bit there. Thank
Just
you.
a tiny bit.
And then, how did you find out about this hearing?
I called the court.
Okay. Why did you think to call the court?
Because I knew it was time was getting closer, and I wanted to see if she was going to renew it or try to.
Okay.
He's got a lot of bling.
I just want to move on with my life, Your Honor.
I understand. Well, we're going to come back to you in a minute as well. We'll give her, sometimes people have trouble with the Zoom. So again, you can mute back up. I'm going to take this one hearing, and then I'll come back and speak with you in a minute.
All right.
That was not pretty.
So Ms. Ramirez, you can come on the Zoom call here now. And Mr. Basenko? Mr. Basenko, I can kind of see the top of your head. You need to adjust your camera there so I can see your face. Keep going. A little bit more.
A little more.
All right, hold it right there. Ms. Ramirez, can you come on the Zoom call, please?
A little Zoom etiquette.
Yes, Your Honor, I'm here.
Could you activate your camera, please?
At this time, Your Honor, I am going to be very honest. I am just coming back over the pass and I am driving. So I
Okay, so
can, but you won't be seeing my face. Unfortunately, I did get stuck somewhere where.
okay. Yeah, we're not going to do this hearing while you're driving. You're basically admitting to an infraction on the road, and that's not going to happen here today. So you just need to stop. You can, if you can find a place to pull over, you can pull over, and then we'll talk about whether we're either going to have the hearing or whether we're going to continue for 2 weeks. But we're not going to do it while you're on the road. We're just not.
All right. Give me 1 second, Your Honor.
Well, you can mute back up.
Yeah, so we don't hear
Or actually,
any more
we'll mute
evidence.
for you. I don't want you messing around with your. Okay. What's that? Okay, thank you.
Yeah. Admitting to infraction. We literally have the evidence right here. The prosecutors work in the same building as the judge. You guys, they're right there.
Okay, Your Honor, I'm here. I am pulled over.
I need your camera, please.
Isabella, please sit back in your seatbelt. Thank you.
Fasten your seatbelt.
This place.
The camera. How do I do this? Sorry, Anna, I'm trying to turn on my settings over here because it's not allowing me to access.
We're still waiting. Is this for Mr. Basanko or for Mr. Workman? Just had a water delivery. Deer Park. Still not a sponsor. Deer Park, you can fix that. Make it in your New Year's resolution. This is taking a long time to turn on the camera.
Say that again. All right. We might have to. All right. I'm going to, I'm just going to step off for a few minutes, and then I'll come back. All right.
The judge has had enough. Says I need a break. Can't do this anymore. All right, the judge is done. He was like, I'm done. I'm out of here. Can't watch BBC, unfortunately. Let's see. Is this one new? Or is that the same one?
You can be seated.
That's the same one. See, Thurston 1.
On behalf of your client, Ms. Simmons, to remove the scram device, let me turn to the state here and see, is there an objection to this motion?
Yes, Your Honor, there is.
Okay, so let me get all the information back up before me. What I'm looking at, just so I have everything that you think I should have, Ms. Simmons, is I've got the competency evaluation, an intake letter from STOP that speaks about scheduled to attend a first session on November 13th of this year. I also have the pretrial services, speaking of the SPRAM device. And then I have a December 4th, 2024 stop treatment compliance report signed by Norman Jones. Just began on November 22nd.
Thanks for the mower aid. Good to have you here.
Saying compliant for 2 out of 2 program attendance. Sober support yet wasn't applicable. They're too early, I'm presuming. Compliant negative results on UAs for November.
And Your Honor,
Okay.
I can update that information too. Just a moment, Your Honor. I have to close my door here.
Okay.
She's back.
Okay, so does the state have all that information?
Yes, Your Honor, I believe so.
Good. Okay. All right. So Ms. Simmons, on behalf of Ms. Black.
Thank you, Your Honor, Ms. Black, and counsel. Your Honor, as stated, Ms. Black you have the letter from stop of her evaluation. She was diagnosed with a mild substance use disorder. Since the time of the compliance review, she's attended 5 groups. They are 1 hour to 1.5 hours each. She has another one-on-one scheduled this week. She has a total of 26 sessions. She's supposed to attend 3 one-on-ones. As the court noted, there is a letter from pretrial services. She has had the SCRAM device on since July 24th. She has had that on for a little over 5 months without any positive results. Prior to the removal of that requirement, she was also getting UAs with friendship diversion. That requirement was eliminated because of the fact that she had the SCRAM on. This is an alcohol-related DUI. She has, as I said, had no violations, done her evaluation at stop at a cost to her because her insurance wouldn't cover it. She also lives in Rochester area. She has to get a ride to and from to go to her treatment classes. This incident occurred at a very unfortunate time without admitting guilt. Miss Black had been successful and had a series of years of sobriety. She was successful at the completion of a deferred prosecution. She found her spouse deceased on the highway about 6 months prior to this happening. As one can imagine, she's very young. This is a very unexpected event. And as I said, after maintaining sobriety for some period of time, she drank again. This incident occurred at about 11 o'clock at night. There was a car in the middle of the roadway with its lights off, and Miss Black did strike that car. A blood alcohol was taken, and she had a breathalyzer result of a 0.195. She did get that evaluation. She's back in treatment.
The other car
we're
had its lights
asking
off?
that requirement be removed. She has to
In the
come
middle
up
of the road.
to Olympia to get the device calibrated. It is very difficult for her to find rides. Her car was totaled as a result of that accident. She also was injured. She doesn't have her license. She works part-time. She is a checker, and it's my understanding that the person that was involved in that event was harassing her for a while. That person has since left the area, according to Miss Black, as far as she knows. She was told by an officer that would get a restraining order against this individual. She realizes the result of her actions. We don't know what would have happened had she been sober, but I don't think there are many of us that could avoid a vehicle in the middle of the highway in the middle of the night with no lights on, regardless of the state of our sobriety. But Miss Black did take responsibility and has done so this entire time. So we're asking that the SCRAM device be removed. She's in treatment. She's doing well. She's being successful. And if there is any indication that drinking is involved, they can give her random UAs. She does them in the area because she would have to get a ride otherwise. So she does them at her doctor's office when they are requested by the treatment provider.
So, Ms. Gitmacher?
Yes, Your Honor. The state's position is that there is not a change in circumstances that warrants removing the SCRAM that was imposed. This is the 3rd time that the defendant has been charged with DUI. As noted, one was dismissed after the completion of deferred prosecution. But ultimately, in this case, it involved a collision, high BAC, 0.195 to 0.219. SCRAM is there for public safety. It's there because of demonstrated history of DUI, and the state's position is that it should remain there for those reasons.
Anything else, Ms. Simmons?
Well, and Your Honor, I'm not sure what would be required. If Miss Black had pled out initially, she'd be in treatment, she'd be doing exactly what she's doing. We can't keep scram devices on people forever because they have prior alcohol-related offenses or current ones. She is doing what the court requires as a result of what happened. She has not resolved this case, and in the interim, she has gotten an evaluation. One of the reasons for doing so is to try to assist with this matter before her. She's taken responsibility. I'm not sure what else she could do. Constant alcohol monitoring, it is difficult. She couldn't see her family over the holidays because she couldn't leave beyond a certain area because there would be no monitoring. I don't know what other price she has to pay. The requirement when one gets an alcohol related incident and a guilty plea, she's done the deferred prosecution. I think the circumstances in this event are ones that not many people could imagine. I think they're out of the ordinary, and she's taken responsibility. She's had that scram device on for community safety. She is in treatment. She has been successful in the past. She is currently successful. I think keeping a scram device on is more punitive now than anything else. If she resolved this case tomorrow, what would the court want for her to maintain the scram forever? I'm not sure. I don't think that's a realistic proposal. The court in the past has allowed people to remove the scram device when they are actively involved in treatment and getting random UA. She is actively involved in treatment. She's done 5 sessions because of the holidays involved. She probably would be able to have done more. She has one this week. She has the support system that perhaps she was lacking, because the death of her spouse impacted her greatly. She was socially isolated because it was just overwhelming. And on one of the occasions that she went out, she said it was the second time she'd gone out, she drank, which was not a wise decision. And that has cost her a great deal.
Just looking at things, see if I have any further questions here. And what I'm looking at, I should say, is the previous, I think it was within 12 years, this is an allegation of a third DUI. And the 2012 was an SOC, it looks like, out of Enumclaw Muni, down to a neg 1. That was successfully reduced after a stipulated order of continuance. And then also about 3 years later, almost exactly, there is another DUI in Enumclaw Muni Court. That was the deferred prosecution. That was dismissed on successful completion of that. And then about, my math is right, almost 9 years later, we have 8.5 years, maybe, if my math is right. We've got yet another DUI here alleged, and all of them, well, at least the 2 that I can access from 2015 and 2024 look like alcohol related with over 0.15 breath samples. So any different information as to that, Ms. Kittmacher?
No additional information than what's in JABS.
Okay, and any disagreement with that summary, Ms. Simmons, as to the history?
No, she did have 8 years of sobriety until this event happened. That is what Ms. Black stated to me.
So, Ms. Black, I do find that there is a substantial change here, and I'm finding that because you're in treatment, you're being monitored for sobriety, you're going to continue to be on pretrial services, and they'll still monitor you for sobriety as well, and they'll be allowed to take UAs and mouth swabs and VACs, whatever they think is appropriate to monitor your sobriety. But I'm going to relieve you of that scram device. You have to have the ignition or lock device on any vehicle you drive if you drive, and of course you don't drive unless you have a good license, and right now you're still suspended, so don't be driving. Right. But no driving without ignition or lock device on whatever vehicle it is, whether you own it or not. But your actions here to get into a treatment program, along with the pretrial services supervision, I think it's going to help keep the community safe and keep you in compliance with the court orders. Now, Ms. Simmons, we've got trial confirmation January 31st, and I know you're moving on to a new job. So I'm thinking I'll just leave that set. Is there a new attorney yet appointed that we should let your client know about?
No, Your Honor, that is my last day in district court, so I'll be able to cover Ms. Black's matter.
Okay, and then we'll see where we go from there. So, Ms. Black, what this means is you're still with pretrial services. You understand that, right?
Yes.
You just can have that substance monitoring device, the SCRAM device, taken off as long as, now what's persuasive here is that you're in treatment and you're doing well. Now, if things change, and I'm going to require that monthly treatment reports, all treatment reports get filed with the prosecuting attorney, okay, Ms. Simmons, so that if there's a change, they can make their motions. So that's part of this, Ms. Black. You gotta get those reports filed with the prosecutor's office. That's part of your release conditions. And just do well, learn everything you need to learn there. And you're going to be back on January 31st at 10:30 for your trial confirmation. We still have trial dates set. We're keeping those set. So make your plans that you would have to be here in person for trial February 10 and 11, if that's what you choose to do, and stay in person, live and in person throughout the entire trial. But the only change is that I'm signing an order here that allows you to have that SCRAM device removed.
Thank you.
Actually, there's two changes, that, and then you shall have those treatment reports filed with the prosecutor's office so they can make sure that you're doing well and there isn't a reason for me to change this decision. All right.
I want Charles to
Okay,
stop
have they
signing.
been filing my report to the prosecuting?
You need to talk to your treatment provider and make sure that that happens.
Okay, I will do that.
Okay, so talk to Stop.
Okay.
I wonder if somebody's missing a stop sign somewhere, or if maybe Charles is a flagger.
Ms. Simmons, anything more for your client?
No, Your Honor, we'll just need to get a copy of that in writing, so she may take that to friendship diversion and get the device removed.
All right, you can get that. And then any questions, Ms. Black, about what happens next?
No.
All right. So
Thank
that's
you.
all for today. We'll see you on January 31st.
Okay, thank you.
You're welcome.
Thank you, counsel.
And Ms. Simmons, do you have any other clients this morning?
Well, Your Honor, I see one on e-defender. I'm not sure that's in the calendar, though, as I was out previously. I don't know if, is Keith on the calendar? I don't know if e-defender.
Yes, it's Keith in the courtroom. Keith not in the courtroom, not on Zoom. Let me finish up this order concerning Ms. Black, and then I'll jump to that. We'll take care of that
Thank you, Your Honor.
matter.
All right. Well, they're doing that. This is the end of the year, and not many courts are doing much. And I feel really close to Charles, like really close. Hello, Charles. How are you doing? I think I should be like bigger. I feel a little bit threatened by Charles's size.
All right. So taking up the Keith matter, that's a competency review hearing on a criminal trespass in the second degree. I see that on another case back in September of 2023, there was a finding of lack of competency. I have to look back to remember why. And this order was signed in May, and we know it's taking at least a year. So any information from the state as to your progress on the case?
And Your Honor.
No, he's not here. I'm wondering what your tenor is on this competency review.
Defendant hasn't completed a competency review as far as the state's
So you're
concerned.
wanting a competency review still? You're still wanting to
Your Honor.
go forward on the 1077 or?
Yes, Your Honor.
Okay.
And frankly, it's concerning that the defendant's here. I don't know where he's at or what's going on or why.
We
he's
turn to
not
Ms.
here.
Simmons. Ms. Simmons?
Your Honor, a competency evaluation was done. The initial charge that was dismissed, Mr. Keith was in custody for, I believe, 11 days. A competency evaluation was done. He was found not competent, and this is a non-restorable offense. It was also noted, and I noted for the court at that time, that he had had an ITA hold with Ms. Norton being his counsel. He was released from jail on a Thursday, and on a Saturday was again charged with criminal trespass in the second degree. Another competency evaluation was requested on that charge, which was heard the following Monday, even though a previous competency evaluation had been done less than a few days later. So he was found not competent. I'm not sure what the purpose of, nor was I at the time, what the purpose of a second competency evaluation days after the first one was performed would be.
Yeah, that seems a little weird.
You know, Mr. Keith, having met with him, and according to the evaluators, he does not track well. He's from Oregon and he's walking to Canada. He was arrested, I believe, and the charges were dismissed. I believe that's in Everett. I have not heard from him.
He's
I
walking
do not
on the
know
trail?
if he is hospitalized. I have had no contact with him. I think the circumstances are egregious. He has been hospitalized for a significant period of time. I think continuing this matter again to have a subsequent evaluation when one was done days earlier is, I don't think there's any point. Quite frankly, I think it is a waste of the court's time. I think it is a waste of Mr. Keith's time as well.
2 of the 3 so far.
Doesn't
Going well.
assist in any way. He has been hospitalized, as I said, for a significant period of time. He was this summer prior to this charge. Shortly after that happened, he was arrested for criminal trespass, as Your Honor can see. The case that occurred on April 9th, the cases that occurred on April 9th and 10th, I believe were exactly the same.
Did it get better, Josh?
He was picked up.
Those were in Evergreen District.
Yeah.
Snow County.
Yeah.
So if in fact he's to be believed to be hiking up to Canada, that would make some sense.
He's closer.
So, all right. So the evaluation that was done was back in March 28th of 2024. He was found not competent on that case 3A515074. And then he was released on that, as you said.
Evaluation was done on March 11th, Your Honor, but the report was completed on the 28th.
There you go. The March report was 28th, and then on the 29th, he was released, March 29th, and then we're back here, an allegation of the next day of criminal trespass 2. I can't remember where that was. All right. So, all right, Mr. Anything to add to?
I would just remind both Ms. Simmons and the court that often we sit here on competency matters and are told time and time again that competency is fluid. And just because he had an evaluation done in the middle of March doesn't mean that he's not competent now or that he wasn't competent on the day in question. Anecdotally, Ms. Simmons might be very accurate, but that's not how we process cases. We have a process to these cases. The defendant is alleged to have committed a crime. Defense is alleged that he is not competent. An evaluation must be conducted. Now, while I know the court said that this is a non-restorable offense, I would partially agree with that, in that every offense can be restorable if the state makes a sufficient showing to the court to restore it. I don't think there's any secret that the state would probably ask to restore this if he was found not competent, because within hours of being released, he goes out and commits another offense. Like the state has great interest in protecting the community, protecting people, protecting the individual defendants too from themselves, and getting them restored and getting them taken care of. And so the defendants failed to appear. Ms. Simmons has had no contact. I imagine he's had no contact with Western State. We'd ask for a bench warrant at this time, Your Honor.
This is on the side of I-5 on March 30th. Once he was released, he was walking southbound I-5 on the right shoulder, and that's when the officer found him.
And the competency evaluation was ordered days after the other one was filed, Your Honor. So I'm not sure, had Mr. Keith been evaluated then,
Well, he was southbound, not north. I don't know where he was headed, but at one point he thought he was going to Canada. At one point he's going south, maybe back to Wilsonville. So I'm not going to issue a warrant. I'm going to set this out to sometime in May for competency review. Send that information. We've got an address for mailing. We've had that all along. The state believes that this is where they should put their efforts on this criminal trespass in the second degree. And so the court can't summarily dismiss. We will take into consideration, you know, what we've got in our court files as previous findings of lack of competency. So let's see if we set this to I have to do this Monday. Put this on a regular old Friday or Wednesday calendar.
We might be going back to Minecraft Court.
Okay, so far
It's a
from now.
gas company that's being sued about a line and where it's at.
10 o'clock. Okay, I'm going to just set May 16th. It's a long time from now, but that's what Western State Hospital is telling us, that they can't get to these things because they're being asked to do things they don't have resources for. So May 16th, we'll mail notice to the address that we've had all along. It hasn't come back. It's been working. And give you the opportunity, or the next attorney who's appointed, to have the opportunity to talk to Mr. Keith and have Western State Hospital continue their efforts.
All right. And while they do that, we're going to see if we can get the ending to the lady who was driving in court a minute ago. Let's back up just a little bit because I think she's back. She starts right here. We're a few minutes back. There's Jason Workman. Russell's back. At least his eyes are.
Once that's taken care of,
he's like, my eyes are down
then
here.
I'll be free to go.
There's Alicia.
You'll be free to go, or we'll take up your hearing. So, all right.
In the car with a filter. I got up and left. He's back. Did you get a new judge? Did he just swap out?
All right. Good morning.
They just hot swapped the judge.
Situation here, and so let me just look at the former order, and I understand that the responding party is not present. Is that correct? All right. Not on Zoom and not in the courtroom. So I will sign the order here.
I get the feeling that Alicia is doing everything she possibly can to mask her appearance or make it difficult to see. I mean, like, I don't know, what do you do? Do you like smear makeup across the camera so it's blurry? She's got the phone down by the floor under the steering wheel. Yep, getting blurrier. The other judge is like, "Look, I can't handle this case. I'm done. If I handle it, I'm gonna have her charged with driving, distracted driving, because I've got all the evidence I need." She admitted to it in my courtroom. And an old pro. She's like, "No, use Vaseline or chapstick."
How was service done in this case? Was it personal service?
No, the sheriff's department went out and
Okay.
served her.
Personal service? Hang on. The other judge said we can't do personal service. She's got the hoodie on, the bright light in the background. The poor camera, placement as far as aiming it at your face. But I mean, look at the other dude. Basanko is not doing much better. We've got one eyebrow from him, and that's it. Judge Hedrick accused himself, couldn't take it anymore. Josh, is it worth going back to the Minecraft court for the lawsuit over the gas pipeline? To be fair, she wasn't under oath when she admitted it. Yeah. Really excited for tomorrow's live stream, tomorrow night, tomorrow afternoon, I guess we should call it. Doing an end of year bash, so we're going to be celebrating a lot of the fun things that happened throughout the year. Reliving some of them, playing them together. Just having a good time. Mostly being a technical nightmare on my side. I'll probably develop an ulcer midway through. But we'll see what happens. And we might let some of you come on and say hi. I know I'm a little I'm not sure. I'm miffed. Is miffed a good word? I'm a little miffed because Phil from TYO Toys went on someone else's live stream and revealed he's got a voice like butter, and has never once offered to come on here with me. Phil, we need to fix that. He might need to come on for the live stream tomorrow. What are your plans? Based on the blurry shadows, Alicia ain't stationary. That and the wheels spinning, going different directions, hand over hand. What do you consider afternoon, Mel? This is a fair criticism. It's been a rough couple days here. This bathroom model is kicking my butt. We have replaced two of the we knew we had one bad joist, tore it up, saw we needed a second joist, tore up more. I think we have to replace a third joist. Pretty much we're replacing everything under our house, which is hard because we're not moving the house. The house stays there. But we'll take you on a tour of that. That'll be tomorrow night. I'll let you into the craziness that is 100+ years of shoddy construction under my house. Looks like she's in the drive-thru to fast food. Oh, that please. Right when she goes to say her name, I think she's chewing gum sideways. Right when she goes to say her name, it's like, all right, ma'am, that'll be $24.68 at the second window.
And like on the temporary order, I'm going to write on instead of the 1,000 feet upon the property of the person, so they can access their property, but they can't have any contact with you, obviously.
Directly across from this.
Right. Okay. Yeah, I saw the video, and you can see her coming out to the edge of your property, but I wasn't sure where the egress was, or so she doesn't need to come onto your property to access her property. I take it.
I bought a new saw blade for my circular saw. I didn't realize I needed to do that. First of all, I'm not a tool guy. I bought this saw 22 years ago. A little battery-powered Ryobi. This was before the nickel metal hydride batteries came out. It was NiCad when I bought it. Okay, and so the battery technology has upgraded since I bought the saw, and I've used that same saw blade for 22 years. Bought a new saw blade at Lowe's this morning. It's like a hot knife through butter. I never knew that you could cut wood that fast. It's unbelievable. I was just like scaring it with my old saw, and it would like rip apart out of fear. But this one, whew. Blade's probably still under warranty. I probably should check. I know that you can handle it safely because there's no sharp edges on it. Yeah, it's a blue saw. It's one of the OG. Most of my Ryobi stuff is blue. She's eating French fries. Is she seriously? Did she get fast food? If she's got like a Frosty, that she's, she's hiding us under the steering wheel. Honestly, when you think, hey, I have to be on Zoom, maybe it's a vape, I don't know. I've got to be on Zoom and I'm in the car. Do you think, what's the worst possible angle we could give?
So does this order need to be then served on productive of the other party? No, it doesn't. It's already been served, the temporary one, so this one does not need it. Okay.
Unless there's changes to.
No, I'm not gonna do any changes, so that should be fine then.
I've got it blown up on my big screen, and if I squint, I can sort of make out where she is in the picture. Clearly, she's here with Mr. Basanko because they have the same skills when it comes to camera aiming. It's her birthday. She's eating the free pancakes.
Look at that and see if I missed any blanks there.
Judges are just doing paperwork. Nope, I don't want that one.
Thank you. Oh, yes. All right.
You were copying.
Marriott School is calling me. You want to hear it? Hello?
Hey, Sean, how are you doing today?
Oh, good.
All right, well, we are here to qualify you. Are you receive your grocery card, food stamps, and cashback benefits, I don't?
You said cashback? Oh, come on. I was playing along. I was being good. Danny Austin gifted 5 memberships. Thank you, Danny. Got some good people there. Horse Feather, drama from my llama mama is there. Sheila, Epon Poindexter, and Jayhawk Jan all gifted memberships. Thank you, Danny. Oh,
Thank you. Thank you. You guys have a good day. Thank you.
was he just signing a warrant? Was that it? Now the other judge is going to step back in? I think he was just doing a warrant. For Mr. Farag, probably. Just missed a call. Jason Merkman's back. Oh, here we go.
So, Mr. Workman, so for whatever reason, Ms. Ziotti has chosen not to be here. It's now 9:45. Given her non-appearance, then
finding for the party who
basically
showed up.
the petition to renew is going to be denied, and then the no contact order will be over. I don't know what happened. I think it's possible that she may, I don't know what happened, but if she may choose to refile or ask for a different order, she can do that. But for the purposes of today, the petition to renew will be denied, and you're free to go. You're muted. If you're speaking to me, I can't hear you.
And speak from further away.
Is that better? Can you hear me now?
Can.
Thank you, Your Honor.
Welcome. You're free to go.
All right.
Rachel Berglund did. I don't see her on there.
Sometimes it pays just to show up to court. If the other party doesn't show up, including the police officer who wrote you the ticket, you might have a successful outcome.
Okay. There's no service on that one. So Ms. Ramirez there, could you unmute and come on the Zoom call?
I am on the Zoom call, Your Honor. I didn't realize, I dropped my phone last night. My screen is a little cracked. I'm trying to get the best view here for you.
Okay.
Oh, really?
So
trying to do the best. It's the best I can do. Didn't realize I dropped my phone yesterday. Yes, I think you realized you dropped your phone.
So he's been served. There's a temporary in place. Given I can barely see you. It's just it's very fuzzy. And
yeah, and I don't have the best service, Your Honor. I'm so sorry.
I know that, and that's what I'm getting at. Is what I'm inclined to do is just renew this temporary and then reconvene in 2 weeks when you're in a better situation and everyone can be heard on this. I see Rachel's here now.
Okay, Your Honor.
Hang on just a second. Do you understand that, Mr. Okay, ma'am, I need you to speak. Quit for a minute. Do you understand that, Mr. Basenko?
Don't talk.
Yes, Your Honor.
Okay. So there's a no contact order in place. We're going to have the actual hearing is going to take place 2 weeks from today, and you'll need to be back here on that date. Do you understand that?
Yes, Your Honor. Is it on a Zoom call or is it in person?
It can be either.
Okay.
So yes, you can be on Zoom just like this.
Is it the same?
Email. I don't have his email, but I have theirs.
Okay. So do you have an email? We can send you a copy of this, Mr. Basenko?
Yes, Your Honor. It's
Can you put that into the chat function?
Yeah.
January 13th.
Yes.
Did you get that?
Yes.
Misconduct. Congratulations on 21 months.
Okay, so you'll both get emailed a copy of this. We'll see you on January 13th at 9 a.m.
Your Honor, I did want to say one thing. That was yesterday. I did make a police report to Lacey PD. And they said you should be able to see that in regards to already breaking the protection order.
It's going to be for the next hearing, ma'am. I just need to let you know, Mr. Basenko, a no contact order. You need to comply with it. Do you understand that?
Yes, Your Honor.
All right. That's it for today. We'll see you back here on the 13th. And ma'am, if you have additional evidence to provide, you can certainly provide it.
Fix your phone.
Okay, thank you, Your Honor.
And then you both are free to go. And then Rachel Berglund, are you on the Zoom call there now?
Suddenly
Yes,
the picture
sir.
gets a lot better as
Could
she's
you
trying to
activate
hang
your camera,
up.
please?
I think someone was lying.
I'm here.
Hey, Rachel. Welcome.
Hi there. So, I'm not sure how to, is it Ionescu? Am I saying that correctly?
I'm not sure, sir.
Okay. So, he doesn't look to me, and looking at the file, in order for this case to proceed, he needs to be served. He needs to be given a copy of this. And I didn't see that he had been served with this. Do you know if that took place?
Sir, so serving him is up to me, and I do not have his physical address for certain. I wanted to ask if a substitute service would be available and if posting would be available, or if I'd be able to deliver it via email.
Do you know where he lives?
I am not sure. He's been harassing me on email for some time. I knew where he lived 5 years ago when I met him in person. But as of the last year or two, I've reached out to people that I know may know him, like his ex-wife, and she doesn't know where he lives now. All she had was his parents' address and said that it's possible that's where he would have his mail sent. So
Well-
I have his phone number, his email, and then I have his parents' address. It's way over in Tennessee.
Tennessee. Is somebody in Tennessee harassing someone in Washington over email? That's no bueno. Don't harass people, guys. That's not nice.
So give me just a second here.
Mm-hmm.
How recently have you heard from him?
Just a couple weeks ago. It's just been going on for a long time.
I know I read the file before I came on the bench here, so I'm aware of that.
Okay.
Not sure if you can serve someone legally with email. You need proof of service. Grincher's is like, let us help. We know some people. Misconduct gifted 5 memberships.
Hang on just a second.
Misconduct. Is that a pixie haircut? What's the name of that?
So what we're going to do here today, ma'am, is we're just going to re-enter the temporary order. A copy of that will get sent to you for service. We're going to reset it for 2 weeks. And what you need to do is going to be, you need to outline
every effort
you have
take
to make
trying to
an effort. And you can try by email, but he may or may not get it, and he can do other methods or whatever you can to try and track him down. And then you kind of need to show that what you've done. And then a judge will look at it and think, okay, well, there's no other way to serve him other than this alternative service. You see what I mean?
Yes, sir. That's why I was asking if a substitute service is available. So like if I would be
there's a thing you have to go through first. You have to expend all reasonable efforts to get him served in the first place. And then you have to show that to a judge. Then we look at secondary or substitute service.
Okay.
So we're going to give you 2 weeks. We're just going to reset it for 2 weeks and then give you an opportunity to do what you can.
What is that on the wall? Is that like
a
key ring?
And the next hearing will be on January 13th.
Okay.
At 9 a.m. And the other thing I want to tell you, ma'am, is, really make an effort. We're all busy and we all got things going on. Make an effort to be on time for the hearing, because frankly, it's kind of by happenstance that you made it hearing. There was this hearing and then there was a delay. And there's a good chance I could have been done with this calendar a half an hour ago. Then you would have, texted or zoomed in, and then no one was here, and the case would get dismissed. So really make an effort to be on time. All right.
Absolutely, sir. I didn't have the details until this morning.
Right.
So will do. Thank you.
That's it for today. Copy of this will get emailed to you. We'll see you back here on the 13th.
Thank you so much, sir. I appreciate it.
You're welcome.
Good luck. Good luck finding him.
Yeah, I'll get a lawyer to help you with this and set up for further proceeding.
Ma'am, in this instance, I would recommend you plead not guilty. Speak to an attorney.
Yes, please.
All right.
This jail cam is brought to you by the internet, which is on that blue cable.
All right. Show a plea of not guilty.
Appoint an attorney.
I'm going to appoint an attorney for you. and set an attorney pretrial
Hey,
for
hey.
January 17th.
Okay.
Will be on Judge Patterson's docket at 8:30. Now, let's talk about your bond. You've been in jail now for 2 days.
Yes.
And are you on probation or parole anywhere?
No, sir.
This would
I
never
really like to
happen
go
in
home and
Georgia.
take care of my period, and I started my period and my cats. That'd be awesome.
All right, where would you go when you left?
I would go to my father's house.
Which is where?
That is in Baroque on Cowles Road. Unless Randy's not at the house, because I heard we can't be in the same home, so it's wherever he's not,
Well,
is where he'll be.
It's gonna be a condition of your bond that you not have any contact with Randy.
Right, correct. So yeah, whatever my rules are, Trisha's following those. I don't like.
Say that again?
I said, whatever my rules are, Trisha is following those. So whatever you say I have to do.
All right, no drugs and no alcohol. I don't
Absolutely,
know if alcohol is involved in this or not.
Nope.
No weapons, no assaultive behavior, and no contact with Randy Tepper.
Okay.
What's your father's name?
Ronald Haskins.
In Baroque?
Yes, sir. I can also stay with Barb Culverson too. She owns the B&B Travel
Okay.
in Colton.
Do you have any children together?
Not together, no. I have 3 boys and he has 2 boys. Adult
Where
boys
are
now.
all the children?
My children live one's in New Jersey, one is in Battle Creek, and one is in Indiana. And then.
All right, so there's no children together in the home here, is that true?
Correct. They're all adult, moved out.
Okay.
And he's got one in the RV and then one in Kalamazoo.
All right, Ms. Tepfer, I'm going to set your bond at $2,000 PR with bond conditions.
Okay. What's PR mean?
Personal recognizance.
Okay.
Means you're going to get out of jail. You don't have anything really recently. You had an earlier domestic violence some years ago under your previous name. They didn't charge it. Well, you had another one.
We had a couple.
They didn't charge this as a second or subsequent offense. But I'm still going to do a PR bond. It's charged as a first offense. You're not going to reside in the home. You've been there for 2 days. The prosecutor could amend this potentially, but at this point, that's all they've charged. Deborah Davis charged it, and she had all the information she would have needed.
Right.
All right, let me recap. You pled not guilty. I appointed an attorney to represent you. That attorney will be designated by the court. They're going to give you her name and number, and I want you to call her and make an appointment to discuss this with her prior to the 17th of January at 8:30. That's your pretrial. Your bond is a $2,000 PR bond, despite the fact that you have previous convictions. Also, there's a condition of no drugs and no alcohol and test on demand of any police officer, probation officer. No contact with Randy Tepfer, no weapons, and no assaultive behavior. All right, Ms. Tepfer, you're good to go. They'll have this form sent out. You can sign it, and then you'll get bonded out here a little bit. Do you have somebody that will come pick you up?
Yes. Yep.
All right, you're good to go.
All right. Thank you so much, Bill.
Okay.
She's out of here.
Have we heard from Tim George?
I think Judge Fleischer is just on
We
break.
got
He's
3
got a
more to
holiday
do,
during
Larry.
this time.
I haven't.
He has taken all his videos down, but
I haven't seen the paperwork on the last two.
All
going
right,
live.
well, here's what I know. Let's see if they said it. I've got Patrick Rogers, who's a possession of methamphetamine and R&O.
I have him, Your Honor.
All right, then we'll do him. And then we have Scott Griffiths. And Debbie wanted input on one of these.
Yeah, I would just need a few minutes to look over that stuff. I haven't seen it yet.
Chrissy, happy birthday to you. We sang this morning, but you might have been gone for that.
Griffiths and Hasselkuss.
Hey, other right. Ayden, come right up. Ayden.
Somebody's yelling in jail.
Well, a lot of yelling going on out there at the jail.
That's what I was saying, Judge.
There's less yelling around here, isn't there?
A little bit.
We need more yelling? All right, I'll see what I can do.
I can't imagine Judge Middleton yelling. Sent me the docket. Josh, I got the link, but here we go.
All right, let's see what I know about Mr. Rogers. I don't think we got any.
I thought it was the wrong room, my bad.
Hang on. Just do it. Just do it. Wearing the Nike shirt.
Okay, I'll trade you for these two.
I think he's going to plead not guilty.
Some prelim dates. Was that on Griffiths?
Should be same as the other ones, 114 and 121.
Yeah, and Ives is the attorney.
All right, thank you. Would you check and see if she got a hold of Tim George?
Yeah. Tell the office she doesn't have his direct phone number. Do you want me to send them an email really quick?
Yeah, please.
Okay. No one can come to the office.
All right. Good afternoon, Mr. Rogers. This is file 242305FY. You're Patrick Lincoln Rogers II?
Yes.
I'm Judge Middleton. I'm here at the courthouse.
I know your
Also
father.
present is the public defender. He's with us also, Larry Westcomb. And you got arrested last night for possession of methamphetamine and resisting and obstructing a police officer. Those are both felonies. R&O is a 2-year felony, and possession of methamphetamine is a 15-year felony, 10-year felony, excuse me, $15,000 fine, and you're on parole. So this wasn't good.
No.
So I'm going to show that you plead not guilty.
Thank you. I never had no meth on me. They found the meth somewhere sitting over somewhere.
All right, well,
I
don't say any more about it, Mr. Rogers. I'll get a lawyer to help you with it. Show you plead not guilty, appoint an attorney.
They found the meth next to me. It wasn't mine. Don't know how.
Set a
Those are
pre-exam
my pants.
for 114-25 at 8:30. PEX for 121-25 at 1. Couple of bond conditions. Pretrial supervision, if you post it, no drugs and no alcohol.
I'm trying to go rehab.
No weapons, no assaultive behavior. Have you talked to your PO yet?
No, listen, so I just went to my PO, last time I seen him, I barely passed my drug test. He says, hey, look, you want help? I said, I think I got this.
I barely
Well,
passed.
Who is your PO?
Jeb.
Oh, boy, he's been busy today.
Yeah, oh yeah. So, I don't know.
Well, don't say any more about it. You're not likely to bond out with a parole hold.
Well, no, because I got a violation, and I don't even know what the violation is.
It's the meth.
They told me I was absconding, and I had a violation. The marshals came to my work looking for me for no reason.
Yeah, you were all, they had an absconding warrant for you. Apparently you missed something. They found.
No, everything.
Okay, well, we'll get a lawyer to help you with this. Bond is $25,000 cash or surety with conditions.
So it's at 2,500?
25,000. I don't think Mr. Miller's gonna let you bond out anyway, so it may be moot. But the prelim and pre-exam day will be January 14th for the pre-exam. We should be able to get some handle on what's what by that time. 3.6 grams of meth are what they found.
That's not good.
Have you slept yet?
Man, I'm up in this drug tank. They won't move me, Middleton. I can't do nothing up here. There's a girl yelling, screaming her head off. They won't move
Yeah, I
me.
hear them. They're gonna move you now that I set the bail.
By now, like you said. So I'm just trying to get back to where I can rest and get back where I'm supposed to be, man.
Fair enough. All right, Mr. Rogers. I'll see you on January 14th at 8:30. All right, thank you. Hello, Ms. Davis.
Hello, Judge.
You got some droopy drawers there. Larry hasn't had a chance to digest either of the two cases we have left, which are Scott Griffiths and Caden Husselcuss. And for that matter, neither have I. They just walked in and handed them to me. I knew they were out there, but I didn't know what the charges were going to be. So Larry, do you wish to consult with them?
Please, Your Honor.
Why don't you go ahead and open the Zoom room there. One of our PDCs for this morning called in, had some difficulty getting here, and she is here now, Amber Stevens. And Mr. George didn't want to make a special trip back to Centerville because his client didn't show up. So he's supposed to be joining us by Zoom here.
Let me check with Josh.
Centerville. Does every state have a Centerville in it? Is there any town name that every state has? Centerville sounds like a common one. I believe he does ride a motorcycle. I'm not sure if he rides it to work, but I think he does ride. Droopy drawers. I just didn't say anything. He just about lost his drawers there walking out of that.
Oh, I didn't tell her who else I needed. No wonder.
Centerville in PA, in Maryland.
All right, one last time. Here's the last two customers I need. Caden Husselcuss and Scott Griffiths. All right, I think that's the last two. All right, thanks. Problem is, now I've got Larry filling up the...
Hey, Siri. What states have a Centerville in it?
There are several places in the United States with the name Centerville, including Virginia, Georgia, Massachusetts.
Thank you, Mr. George, for joining us.
Yes, sir.
Let me get Larry situated here. Somebody's got their hand raised. Is that you, Larry?
Not me, Your Honor.
Can you guys think of another city that's more popular than that?
Somebody's been doing a lot of yelling out there at the jail. We're not sure who it is. It might be our poor friend. Waiting psychiatric evaluation.
That is terrible. A jail is not the place to have somebody who needs psychiatric help.
Ms. Stevens, why don't you come up here and have a seat?
Okay, new shirt. What does this one say? Something number 1. Is that ESPN?
Good afternoon, sir. Are you Caden Husselcuss?
Yes, ma'am.
I'm Judge Middleton, and Mr. Wescombe from the Public Defender's Office wants an opportunity to speak with you before I start this arraignment. So let me set up a breakout room and let the two of you go into it.
I need to know what that shirt is. Something LE
All right,
number
just
1.
click join.
Oh, he's gone. So Washington and Greenville, which is funny because I'm in Greenville, North Carolina.
We are addressing now the matter of People versus Amber Lynn Stevens.
And Washington.
That's
we
you.
call it Little Washington.
Yeah. Ms. Stevens is here. She's charged with domestic violence, 3rd offense, and resisting and obstructing a police officer. Those are both felonies. The resisting and obstructing charge is a felony, punishable by up to 2 years in prison. The domestic violence 3rd offense is a felony, punishable by up to 5 years imprisonment. The matter was set for a pre-exam conference this morning, and Mr. Robert was here from the prosecutor's office, and Mr. George was here. Ms. Stevens was not. She called and said she couldn't get here or wasn't going to be here. And Mr. George said she had not contacted him and made any effort to discuss this case prior to the hearing. So I advised staff to advise her that she needed to be here. And so she did come. It's now 1 o'clock. This incident was December 18th. The defendant posted bond, I think the very next day, a $10,000 bond, and then didn't show up.
Whoa.
So rather than issue a bench warrant for your arrest, I thought I would see whether you did show up. The prosecutor has made a plea offer, according to Mr. Robert, that they would dismiss the domestic violence 3rd offense charge and the assault and resist a police officer felony for a plea to attempting to resist or obstruct a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Because you never contacted your lawyer, he's never had an opportunity to discuss that with you. What happened this morning?
Well, this morning I had gotten the PEC and the prelim mixed up. And I also had a interview this morning at another job at 10 a.m. and I hang
on.
I guess I had just gotten my times mixed up.
You skipped court
between everything going on and arranging the ride here.
No.
Really.
Well, where are you staying?
I'm staying on South Street and Flowerfield. It's my grandparents' rental property, and the lady that stays there, she's not there right now, so they're letting me just kind of like stay there temporarily as we have no contact. Me and my grandma don't have any contact.
Yes.
Can't wait for him to appear before the judge, see if he has an attitude.
All right, we have a couple options. One is to put you in jail and let you sit there and make sure that you show up for your next hearing. You won't need to have a job application if you're going to be sitting in jail. So this is a priority over other things. And I guess I have to cut you a little bit of slack because there were some holidays in there. But this happened, you got an attorney appointed for you on December 19th. Today's December 30th, and you never called your lawyer to make an appointment to discuss it with them. What's up with that?
I was meaning to. I can get into contact with him immediately.
This is not
after this.
Same thing. If I put you in jail, he'll be able to come visit you in jail. I'm not very happy about this. You didn't bother to call your lawyer.
Here
This
comes
is
the
about
yelling.
the fourth time you've been charged with assaulting your grandmother. Alcohol was involved, according to the affidavit of probable cause. You don't make the slightest effort to call your lawyer. You don't show up when you're supposed to. You show up 5 hours late at an inconvenience to everybody else. And it's not a good situation. There's an offer of a misdemeanor, but I don't think you're prepared to discuss that with your lawyer. He's not here. Mr. George, would you ask me to adjourn this?
Yes, Your Honor. I just signed some substitutions for matters that are set for next Tuesday. So I just asked that this be set alongside with those because I'll be there anyways.
All right, I'm going to set a pre-exam for Tuesday, January 7. I tried to call both of your numbers, or maybe I didn't. Does the 7388 number work?
No,
Does the 2388 number work?
no.
All right, when I send you out to the counter, I want you to give them your contact information. You are hereby ordered to call your lawyer. Now, there are going to be 2 vacation days. Tomorrow's New Year's Eve. The next day is New Year's. Mr. George, will you be in the office on January 2nd?
On Thursday, I will.
All right, I want you to call your lawyer on Thursday. All right, as you indicated, there's a no contact provision. So you're not to have contact with your grandmother. You're not to use any drugs or alcohol. You're not to get in any other trouble. And it's an additional order that you call your lawyer on Thursday, January 2nd, to discuss this matter with him. And somebody put up money for a $10,000 bond, and
they're not going to be happy.
You don't want to forfeit that. All right. Thank you, Mr. George.
Thank you, Your Honor.
You go with the court officer. Give them your contact information, your phone number. We'll give you the notice regarding your next hearing date. All right. Now I need to close the breakout room. Take 60 seconds.
That'll kick
my
them
life.
Zoom is the new reality. Takes 60 seconds to kick people out. They'll be popped back in here. We're going to have Mr. Rule number 1, I'm always right. Shirt back.
$12 seconds.
But who's counting? 3, 2, 1, 0. Here he is. Sorry, I'm covering up.
Oh, we got
it
Mr.
changed.
Griffiths. What'd they do with Mr. Hasselkuss? Well, I'm gonna do the same thing. Mr. Griffiths, I'm gonna put you in a breakout room and let you talk to Mr. Wescombe. He's the public defender. And then I'm gonna do your arraignment. So somehow they swapped out the cases before we were ready, but just it should join you automatically.
So now we get to wait again. Mr. Hasselhoff disappeared. Have you ever been? This is how I wait until my chat timeouts. Have you ever been like on? I know you have. You've been on YouTube or, in my case, Amazon, and you're not sure how you ended up where you are.
Let's see what Mr. Griffiths is about.
But suddenly, I find myself shopping for lapidary slab saws.
That Tricia Tepfer
I'm looking at a 10-inch slab saw.
had 1 or 2
cutting
previous
rock
DV
glass.
charges, but they were old.
Conviction.
Diamond saw
She
blades.
did, I thought. Maybe I got it wrong.
The lane that I had was clear.
I thought one was a deferral. Boy.
How did I live so long without a lapidary slab saw? I have rocks to cut. I kid you not. Hang on.
Probation revoked. Girl Ryan Smith. She had 1 and 13. And then
Was it a different last name or something?
Haskins, I think. And she had a DV second at 14. Probation also revoked.
That was not on her criminal history, so we will.
She's under Haskins, so she has 2 previous domestic violence convictions.
So this
Okay.
albeit
here.
a number of years old.
Watch this. I cut this one already.
I told her that you might review that.
Yes. I was a little surprised that there was nothing prior. So it was a busy morning with in custody today. too, so.
Yes. I didn't get a criminal history.
Well, if it's the same one that I got, it wouldn't have helped you. So.
Well, they became non-pub. Well, no, they. I don't know what happened to them. They shouldn't have gone non-public.
Then I got this one as well.
But I think it was under a different name. All right, let's see what I can tell about Mr. Griffiths. He's not in my queue.
So I need to cut these
There
down
he
to make
is.
jewelry out of them.
Shayna.
Literally, the CCH has nothing, no identifiable record.
Hmm.
I'll contact the officer.
These are rocks I picked up from a river I was fishing years and years ago. I carried them around and moved across the country with them. And I picked them up because I knew that inside there were just there was just a secret that waiting to be revealed. And these are, if I spill some water on it, it works really good. Hang on.
Wow.
Gonna try to not hit my laptop.
12, 24, 36, 48, 60, 72, 84.
Just counting?
Mr. Griffiths has 84 separate entries in here.
And there's multi-state.
That's just for Michigan. Okay, so look at this rock.
Who's in it?
You got this one?
Whoever's in Scott Griffiths, will you get out of it?
Okay, once it's polished, it'll look like that. Dry, it looks like this. Polished, looks like that. Just add water to it to show what it looks like. So I think that would make like a nice slab. You can cut and make little pendants and things out of that.
This has an FY number on it. It's aggravated domestic second offense, so it's a second aggravated, so that makes it a felony. All right, got it. I thought it was just a second.
Okay, and then this one, cut when it's polished, looks like that. See the difference? Looks really cool, huh? Nice rocks. So now I need a lapidary saw. I cut these on my friend's tile saw.
I don't have any praxis report on either of these. I don't think anyone is here from Community Corrections Office, but I've known Mr. Griffiths for a long time.
Oh, my chair is too close. It slid. It was under my desk. There we go. So, yeah, it goes like this. You buy the tile saw, and then you can cut little slabs, little pieces. And then you have to buy the polishing one with like 6 different wheels. And or a tumbler. A tumbler would work. I need to put a lid on this water before I spill it. Because like, you do need that. No, you don't. I bet he didn't like your cactus as much as your rocks. Harsh words, Deanne. Harsh words, especially knowing that my cactus is no longer around. The person I gave it to did not keep it alive. Don't get a dilapidated lapidary saw. Is that a thing?
It's interesting. The praxis I got emailed on Tepfer, she didn't mention that she had any prior convictions as an adult.
I think that's exactly it, Jim. The big tile saws are expensive, like $1,000 for a 10-inch. If you want like a 14-inch, big money.
Both of these from 8:31 this morning.
The bigger the saw, the bigger the rock you can cut.
Well,
I'll forward it to you and Larry.
Libby Lou.
Let me look under the Haskins name, because these are purple, means there's a different name.
See, I watch YouTube videos of people cutting and polishing rocks. It's like, I just want to try that.
Oops, if I could spell.
Francis, I'm starting the Rock Soft Fund. I've always thought rocks were beautiful.
Just forwarded you the praxis for both of these
I have a box of rocks that I've had since I was a kid.
So I sent it to him and you.
Okay.
You're gonna do it.
And the weird thing is, I can remember exactly where I was, where I picked up most of them. I mean, there's a rock I got at a certain spot where there's a quartz outcropping on the top.
Yeah,
of the
they're all
mountain
under
peak,
the name
I know exactly where to
Haskins.
go back to get more of it.
No, they didn't send it to me. Let me see, maybe it's in my email. Maybe they sent it to Luke's email.
It's the joke, but I would go hiking. I would go hiking with an empty backpack, and I'd come back carrying a pack full of rocks, which no backpack makes feel good. but for the record, they don't make rock pickup backpacks. And now I moved. Do you live stream it? Yeah, cut in a rock for sure. Agate Dad. I haven't seen Agate Dad yet. I'll have to look for him. We're just waiting for the defendants to pop back in. We've got 2 more with Judge Middleton. Jim Bob, when you're not finding metal, the least I can do is find rocks.
Two seconds. All right, we're back. Mr. Griffiths, let's return to your case. It's file number 242306FY, People versus Scott Raymond Griffiths. Prosecuting Attorney-elect Deborah Davis is here. I want to call her that for one last day. And Mr. Larry Wescombe is here for the Public Defender's Office. You've been charged with domestic violence aggravated as a second offense, making that a felony punishable by up to 5 years imprisonment. Count 2 is domestic violence, second offense, which is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. They also charge as a 4th habitual offender, making that 5-year felony offense, I believe, life offense maximum. It's alleged that this took place on December 29th out in Leonidas Township. Ms. Davis emailed me and she wanted to be heard regarding your bond. Let me ask you a couple questions. Are you still living in Vicksburg?
Yes.
Who do you live with?
Tomato Troy, thank you. You got busy. That is awesome.
My oldest daughter still living in Spring right now. My youngest daughter, Brooklyn, that I have a kid with Miss Merkel. Her oldest daughter that just had a baby, and her baby daddy, and Karen.
Oh, Karen lives there also?
I am never going to understand what baby daddy means. I realize it's a simple word. It probably means the baby's daddy.
Yes.
But
where's that?
Used in context, it always throws me
Place for
off.
construction.
Jojo,
who's that?
Thank you. Welcome to the gallery.
It's a construction company out of Lawton.
Okay. I was looking at your stuff, getting prepared for this, and I've known you for a long time. You have 84 separate entries in our system since you turned about 17. Ms. Davis wanted to give specific input on this. Ms. Davis, what would you like me to know?
Your Honor, in reviewing this case, the concern is that this is a continual issue with domestic violence and this individual. He most recently had a domestic charge, 2 domestic charges in Indiana. He pled to one for a dismissal in the other.
Where was that?
LaPorte County. There was also an residential entry, intimidation, and battery in Elkhart County that I'm waiting to hear back from Elkhart to see if the assault and battery that he pled to was actually a domestic, but I haven't been able to get the details on that yet. He also, with the same victim in 2019, was charged with assault with a dangerous weapon. He ended up pleading down to disturbing the peace. He's had multiple instances of driving issues, reckless driving. Dangerous driving was a part of the issue here. This is alleged to have happened in his motor vehicle while they were traveling down the roadway on Michigan Avenue up in Leonidas Township. He's had prior meth charges, resisting and obstructing police officers. He's got both the Indiana record and the Michigan record. With what has occurred here, the victim reported that she is very scared. She was afraid that he was going to come find her. She was hesitant to even go to the hospital because of her fear of him coming to find her. So I would ask that the bond be set as a cash bond with provisions that he have no contact with the victim or her place of residence, that he be placed on a GPS monitoring so that we can keep track of where he is to ensure the safety of the victim, and that there be no drugs or alcohol. It was alleged that there was alcohol as an issue here in this one, and he has a prior drug history. So with that, I would ask that it not be a 10% bond either. I'd ask it to be set as a cash bond and an amount that the court deems appropriate. Thank you.
I can take a drug test. That had nothing to do with.
All right, well, just a minute. The bond information report indicates that she went to the hospital, to the emergency. Do you have the medical information on this yet?
I don't have the medical records. I just have from her that she was treated at the hospital, and was told to follow up with her primary care physician.
It was all about custody of our daughter. Okay,
hey, sir, stop.
Well, what she says in the plain old vernacular is that you beat the shit out of her and she got out of the car.
If that was the case, she'd be all
Stop. I don't want you to say anything that might implicate you in any of this. So I'm not unwilling to hear what you have to say, but at this point, it's probably best you don't say anything. There's a lot of baggage on here. There's a couple of DVs that were charged and either dismissed or reduced to something else. There is a domestic violence from 2019, which is the precursor for this case.
Yeah, it's I have evidence.
Now are you on probation or parole?
No.
In Indiana or here?
No.
Do you have any charges pending in Indiana?
No.
This guy.
I'm not a violent man. It's
all right. Well, don't say any more. Your record speaks differently. You got R&Os, disturbing the peace, several prior DVs, not to mention all the other stuff. But Mr. Westcomb, you have any input on this?
Yes, Your Honor. While these are serious accusations, Mr. Griffiths has acknowledged to me that he will abide by any terms of bond that the court sets, including alcohol and drug testing, and he has a place to go, so there will be no contact with the alleged victim in this instance. The threat to the public, as far as that can be reasonably alleviated with a GPS tether, as the prosecutor has suggested, and he has indicated to me that that is something that he would submit to. He's gainfully employed, and he has been for some time. With all these factors taken into account, we would ask the court to consider, if it sets a high cash bond amount, to consider 10% so that he can assist in his defense. Thank you.
Mr. Griffiths, tell me more about this Lakeshore Construction.
He's respectful.
Well, do you have a project that you're working on right now?
Yes. I was supposed to be finishing a job over by Saginaw on a roof. We always have projects. We're busy all the time. I mean, I'm running.
All right. Do you have a valid driver's license?
Yes.
You do?
Yeah.
Oh, good.
Well, good.
All right. Well, there are public
Wow.
safety concerns. Let me look at this praxis report that I didn't get.
Major ones.
The defendant has at least one prior conviction as an adult. The defendant has 2 or more prior violent convictions. The defendant has a history of drug abuse and does not include alcohol. They recommend pretrial supervision.
It's whatever I gotta do to get out. I just gotta be out working. It's not gonna be
Now,
either.
everybody wants to get out. I certainly would agree with that. There's a public safety component to this. Your girlfriend contends that you beat her. She got dumped out of the car or jumped out of the car, hid to avoid you finding her. An ambulance came. They took her to the hospital. The police didn't mess around. They went right to your house and arrested you in Vicksburg and took you to jail. So there is a public safety issue of it. All right, well, let's talk about the test as directed 2 times. No drugs, no alcohol. No drugs, no alcohol. No contact with Karen Merkel. No weapons, no assaultive behavior. Pretrial supervision, including GPS tether. Bond is $10,000 cash or surety. This is a second offense, aggravated domestic assault, as a 4th habitual offender. I take this quite seriously. So you got the conditions. If you do post the bond, you'll have to contact the Community Corrections Department. I'm going to appoint an attorney.
How much is this?
$10,000 cash or surety.
So if I go through bonds, maybe it's 1,000.
Yes.
Oh, wow.
PEC for 12/14/24 at 8:30.
114 run.
114, thank you. 25 to
1,000.
114/25. Let me get that right. And a prelim if needed for 121/25 at 1 o'clock. Mr. Griffiths, I don't even know what to say about this. At this time, you're presumed to be not guilty. You have a presumption of innocence that follows you throughout this. But I am concerned about this and about you. So I'm not going to do a 10% bond. I'm not going to set it at an outrageous amount, but I have a serious concern about her safety. All right, you're good to go.
If you give me the opportunity, I'll show you.
Judge cut him off. Now Judge is calling the jail back saying, bring our other guy back. You took him before we were done. He probably just thought he was done.
We finished with Mr. Griffiths, but Debbie would like to know if you'd bring Mr. Hasselkuss back in. All right, thank you. Thank you.
On the first time,
if I ask on her behalf, they always.
Debbie would like this.
In jail, or does that work other places too?
You never know. Sometimes it backfires, so gotta use it very carefully.
I don't know much about this one either, so let me take a minute here.
Skipping the line at restaurants?
Curly's maybe.
I got 3 more envelopes in the mail this morning, going out. One for Amber, Michelle, Don
Disney
Nelson,
World, places like that.
and Tim and Vicky. Stickers headed out to your way. Thank you for the self-addressed stamped envelopes.
Let me look at the praxis on this one.
TYO Toys. So you're saying you want my people to talk to your people? I don't have any people. I mean, my mods are overworked. If I assign them to do that, that's not good. That's not nice. You didn't tell me. I mean, I know we got talent with the small cars. I've got a beautiful Sprinter van sitting next to me over here on the shelf. But I didn't know you had a radio voice.
Shana, I've only got one hustle cuss case.
The box is green. That's why it appears clear. But
Shows there are 242307. I have that one.
it's a nice little truck.
Oh, it's just in here twice. It's on here
This
twice.
is 8242174.
Politics.
Well, he was arrested last week.
He was?
So is that the?
Well, I have
okay.
230. It's just in here
It's
twice.
an SM, right?
No, it's a FY.
Can you
The
show me what you're?
right here. 2307. It's got that twice, but it's the same.
Oh, yeah. So no, that just means he has an alias. So two different names. We have to alias him. Does that make sense? It's just one case. So open up one of the 2307 FYs and I'll show you what I'm talking about. Sorry, I'm eating lunch at my desk, so just a warning. And it's tuna, so.
And it's tuna.
Okay, so
Sorry.
control. May I? And then we're gonna go to.
No, I have
page-
people. I have mods.
See where that says an alias?
But assigning you
We
extra
go right
chores.
here. That's gonna show you all the names he goes by. So this is Caden D. Taz. His complaint came in Caden Hasselkas, but I knew that they were the same person, but we just
All right.
have the alias.
Now it says here he's on release from another jurisdiction. I don't- What's your alias?
I don't have one yet.
Okay. All right. Thank you.
Yep, no problem. May I take these?
Yes, please. My alternate ego. All right. All right.
Eating at your
Let's
desk.
take another
Tuna
crack
fish.
at this. This is file number 242307 FY, People versus Caden T. Hasselkuss. Mr. Hasselkuss was here earlier this month on a disturbing the peace. These charges are significantly more serious. It's alleged that on or about December 20th in the city of Three Rivers, did carry or possess butane, an explosive or combustible substance with the intent to damage or destroy property without permission of the property owner, and did damage property belonging to Goodwill Industries. It's a felony
attacked him.
punishable by up to 20 years imprisonment and a fine of up to $15,000.
You attacked a
Your Honor,
Goodwill?
that was on December 29th.
Oh,
Not-
December 29th. Yes, I'm sorry.
That was yesterday?
Count two, did being a person 18 years or older possess methamphetamine within 1,000 feet of a school, which is a 20-year felony. I have not seen that charged this year, I don't think.
Well, just did.
Count three, arson, preparation to burn. Did arrange, place, devise, or distribute an inflammable, combustible, or explosive material, liquid, substance, or device at or near Goodwill Industries with the intent to commit arson of property having a value of $20,000 or more.
Why would you burn down a Goodwill?
I
mean, their name's literally Good.
Officers were dispatched to a large fire behind the Goodwill store. And there's video of someone they believe to be you.
Oh, there's video.
Wow. Setting this fire. Damaging a truck. You had some methamphetamine in your possession when they arrested you. Mr. Hasselkuss, are you on bond in any other jurisdiction?
Yeah.
Elkhart?
The
Did you say
St. Joe.
Saint? All right.
These are some serious charges.
Are you still homeless?
Yeah.
And you said you're on bond from where?
St. Joe.
I don't think he is. The only case that I'm showing is the one that
He owes money on.
Right.
Well, then the praxis is not right. All right. Miss Deborah Davis, the soon-to-be prosecutor, is here. She wanted to give input on this. Miss Davis?
Right, I've been in contact with Rivers Police Department, who have been investigating this issue, and they are very concerned about the safety of the community with this individual. Most recently, at the beginning of December, he was charged with using a baseball bat to hit the backside of a car of an individual. That was the case that he came in and ended up pleading to disturbing the peace. Didn't really have a great explanation for why he did that. I thought they were laughing at him or talking about him or something.
Yes.
And, I had some concerns about him at that point. So when this came in and we start looking at the details, this could have been extremely serious as far as but for the security company from one of the neighboring businesses having a good monitoring system, that an individual called in from Detroit directly to the fire department, and the fire department was able to get dispatched out there much more quickly than usual and get it under control. But the butane that he is alleged to have used and admitted to using, and burning these pallets that were up next to the building, it creates a very dangerous situation for the community and for all the firefighters and personnel that need to be out there to take care of that. He didn't really have any qualms about telling the officers that he had done it, didn't really have a reason, which is concerning. And then the methamphetamine being at the soup kitchen where he was found within about 500 feet of Ruth Hoppen Elementary. And he didn't mention anything about having that. It was then found on his person when he was threatening to swallow it in the police car. I think he's got some pretty significant issues going on right now. And the fact that he is homeless, doesn't have anywhere to go, and this is the second crime that he's committed in this month, I think for public safety reasons and to ensure that he appears and is clean and sober for the proceedings, I would ask that the court set a high bond, no 10% option, and that he be outfitted with a GPS monitor. Thank you.
Mr. Westcomb, anything you wish to add?
Yes, Your Honor.
Well, these are
Given all the
serious
things
charges.
that the prosecutor has mentioned about these charges, they are severe charges.
Yeah.
And I would just like the court to consider the fact that the defendant here is homeless and has access to very limited amounts of resources, and to consider his lack of resources when setting bond. Thank you.
If he was
Mr.
trying to stay
Hasselkuss,
warm,
I dealt with
that's
you
one thing.
earlier this month, that incident where you broke the taillight out of that car with a bat because you thought people were laughing at you. Maybe they were, I don't know. But anyway, it was upsetting to you. And I could tell at that point that there were some mental health issues, but I didn't really delve into it. I just let you out of jail and gave you a fine and time to pay it. Maybe it needed more attention than that. This is scary and frightening and makes the hair on the back of my neck stand up. According to the video, you stacked those skids or pellets up there, put stuff on it, lit it with a butane torch, and caught a semi on fire that burned up, doing substantial damage. And only because of somebody else's security, that whole strip mall would have burned up all the way down to probably Bigby Coffee. That would have been the biggest fire in Three Rivers in the last 100 years. We're gonna need to get some probably mental health involvement here, but this is very frightening. There's no reason for it. Great risk of public harm. And I'm gonna set bond at $100,000 cash or surety.
Ooh.
The public safety implications of this case are very large. As a practical matter, as Mr. Westcomb said, you don't have very many resources, but I asked you this when I saw you earlier this month. Where are your people? Where's your family?
It's just me.
Where do your parents live?
Oh.
All right. Much as mental illness and a combination of both, but there's a great public safety risk. So I'm going to set the bond conditions at no drugs and no alcohol, no weapons, no assaulty behavior, and pretrial supervision, including GPS tether, if you do bond out, which is not likely. But that's by... For your safety and the safety of the public right now, the best place for you to be is where you are. Perhaps there could be some other sort of mental health placement yet to be determined. Anyway, I'm going to appoint an attorney. I'm going to set pre-exam conference for January 14th, 2025 at 8:30 a.m. That's your next court date. And if we do need a preliminary examination, you essentially admitted everything to the officers. It's probably another category of something that will seem like a good idea at the time, but as we're talking right now, you probably don't even really know why you did this. But we'll try to get to the bottom of it. All right, your next court date is January 14th. We'll appoint an attorney and they'll come out and see you at the jail. Hopefully maybe after a day or two of forced sobriety, you'll be in a little better communication. All right, good luck, sir.
Yeah.
Wow.
I'll be glad when Luke comes back.
Yeah, what is that?
All right, that finishes our day and our year and our month. And we'll be in recess when we come back on January 2nd. It'll be a whole new year and a whole new...
I will start writing the wrong dates on papers then. Sounds good, Judge. Sounds great. I think that pretty much takes us to the end of the day. I'm not sure if anyone else is still up and doing anything. Maybe.
It's time. You take care and have a great year.
Thank you very much.
Is he done?
Your Honor, I did take a look at all the plates. All of them are invalid registration certificates and all of them are up to date. So I'm willing to do a motion for dismissal on all of them.
Thank you.
Merry
I have
Christmas.
a couple of unmarked. I know for certain Mr. Coppola is here.
This guy, he reminds me
So
of
as those come up,
Archie comic book. The hair just slicks
take care
straight
of
back.
that forthwith. Good afternoon, sir. This is case number 24 RO 08597, People versus Charles David Coppola. That's you, sir?
Yes.
Thank you, Mr. Coppola. Officer Pendle informs this court that she checked all of the plates on today's docket and yours is updated. Is that so?
Yes.
All right. She's moving to dismiss. You don't have a problem with that, do you?
No.
No, I do not.
All right.
Thank you,
Good
Officer
luck to you.
Kendall.
Thank you.
Little smile there. Can fly through these. Unless somebody really wants to pay the fine. Judge bringing in the next victim. Defendant. Dagwood. That's it. Dagwood. He just needs the blue. So tomorrow we're going to have a morning stream. I'll hopefully be on a little earlier than I was today. And then we're going to take lunch, and then we'll come back.
The party mark Wing Tech. What is your name, please?
Come back in the afternoon with end of year celebration. Hey, Wing Tech. Welcome.
What is your name, please? Sir, can you hear the court?
Judge needs to start waving. Be like, hey, can you hear me?
Sir?
I say that because my wife handed me food I didn't know. Oh, look at this salad. Look at this.
Sir, can you hear the court?
It's beautiful.
Hello?
There you are. What is
Welcome.
your name, please?
Thanks for joining
Ian
us.
Fithian.
Say that again.
Ian Fithian.
All right, Mr. Fithian will be with you shortly. You were unmarked. I'm going to rename your device.
I'm on the phone, honey.
Who's that?
I'm on the phone. The judge.
Oh, hi.
No. I'll be right there, honey, okay?
Hello, so.
Ian.
The cop's cracking up. Judge is going to give him a minute to get the kid out.
Officer, I can't seem to get this person unmuted. So if it is what it is, we'll let them go with that motion to dismiss. If not, not. So I think you're all complete.
All right, thank you, Your Honor. I have Officer Keikos and Sergeant Brown here.
Terrific. Thank you. What do you got?
This is not Officer Kendall.
Good afternoon.
Good afternoon.
This is case number 24 RO08463. This is people of the City of Royal Oak. Oh, I'm sorry, Officer Brown.
Yes, Your Honor.
This is not Ms. Smith. Your one matter, I am being told, has had an appearance filed.
Oh, perfect.
So that concludes your broadcast day very quickly. So we can just get Officer Keikos lined up, and you have a safe one.
All right. You have a good day, sir.
You as well. Thank you. Happy New Year.
Same to you.
This is case number 24 RO08463. This is people of the City of Royal Oak versus Carla Lorraine Ijaz.
Yep.
Ms. Ijaz, welcome to the 44th District Court. I believe you may have been present earlier today when the court explained the informal hearing process.
Yes.
And so you heard the court also explain that you must select from one of three options related to your rights, correct?
Correct.
Ms. Ijaz, the citation before the court was written on November the 4th of this year at 7:45 in the morning. You were operating a 2021 Jeep Grand Cherokee white in color eastbound Lincoln at or near Campbell in the City of Royal Oak. And at that place and time, it was discovered the plate had expired on September the 24th.
Is that 8:15?
So you may admit responsibility in this matter. You can admit and explain, which would include confirming an updated registration certificate, or you can deny responsibility and we'll swear parties to take testimonies. What do you wish the court to do for you?
Sure. Yes, admit and explain.
Very well. So you're confirming to the court you were operating a motor vehicle in the City of Royal Oak that place and time, and the plate on the vehicle had expired, correct?
Correct.
All right. What would you like the court to know?
Yep, it was expired. It was just a miscommunication between my husband and I do have proof of registration now.
So your husband was the guy with the September birthday?
Correct.
Okay. Do you have that certificate handy?
I do.
Why don't you hold that up to your device
Okay.
and
Say my name.
Officer
Carla
Pickles?
Lorraine Ejaz.
Yes, Your Honor, I did check through Lien SOS as well. They were
We're not gonna
updated. I
have
make a
her.
motion to dismiss the citation.
All right, motion to dismiss. Ms. Ejaz, you don't have a problem with that, do you?
No, thank you.
All right, your husband's gonna keep having those birthdays until he doesn't. Take care.
Thank you. Bye-bye.
Bye-bye.
All right. No kids this time.
Calling case numbers 24 RO 08222 and 222A. These are both people of the City of Royal Oak versus Ian Charles Fithian, correct?
Vivian, yeah.
All right, Mr. Fithian, we are ready to proceed?
Okay.
Well, I'm asking you.
Yes, I'm ready.
Okay, I just wanted to make sure, the court has no issues with your curious offspring, but we want to make sure we can get through the hearing smoothly. So, Mr. Vivian, you were present earlier when the court explained the informal hearing process, correct?
Yes.
And the court also explained you must select from one of three options to protect your rights, correct? Okay.
Correct.
Mr. Fithian, the citation before the court was issued on October the 26th of this year at about 3 p.m. You were operating a 2011 Dodge Charger black in color, southbound Woodward, M1 at or near 12 Mile Road, City of Royal Oak. And at that place in time, the vehicle plate had expired. And as well, there was a failure to produce ready proof of insurance upon the officer's request. So these are two non-moving violations of expired plates and no proof of insurance, generally easy to remedy, but you do have your three options, sir. You must either admit responsibility, admit and explain, which could include you displaying your updated paperwork, or you can deny responsibility.
I have the updated paperwork.
Okay, I still need to take a plea, so as of the date of.
I admit responsibility.
Very well. And so you were operating a motor vehicle in the City of Royal Oak at that place and time with expired plates and no proof on you, correct?
Correct.
All right. You got updated paperwork.
I do.
Can you display it to your device?
Okay, here's the registration.
All right, bring it in closer and say your name.
Ian Fithian.
Officer Pickles?
Yes, Your Honor. I also did check through Lien SOS. The plates were updated.
All right.
I'll make a motion to dismiss the expired plates.
Motion to dismiss on the plate. Might you have a proof of insurance?
Geico.
Oh, that's really tiny. Can you bring that in closer, please?
Yeah.
Okay. Does it say the effective date anywhere? And then can you read me the last four of the VIN number on that?
It doesn't say the effective date on it. I got it like 3 days later. It doesn't say the effective date on there. I don't even know how to look that up, how I would do that.
It's usually in one of the upper right or left corners. Officer?
Yes, Your Honor. I mean, if he could provide the proof of insurance to the court some way. I believe that he didn't have proof of insurance at the time of the traffic stop.
Right.
Provide that through the court somehow, and then I believe it's if I can recall correctly, it's just like a $25 fine if he did have it at the time of the stop.
That's correct.
If he can just provide that to the court, I'll be satisfied with that.
Okay.
Also, I didn't have the address on the back of the license. I got that now.
Okay,
Okay.
perfect. Appreciate
That was a verbal warning, but thank you for doing that as well, Mr. Fithian. So what the court is going to do is at this time assess $25. And what the court advises you to do to save yourself $25 is if defendant reports to court with proof of insurance, waive fine. How's that?
That works. You guys open tomorrow?
Negative. We are
Okay,
open
so
Thursday.
I'll be there Thursday.
All right. We'll see you then.
All right. Thank you.
Get that taken care of within 14 days regardless, okay?
Thank you. I will.
Thank you.
Yep.
Officer, we have one more unmarked device, but Detective Meckel has been lurking about. I'm going to see what he.
And he bailed on us. Disappeared. Trying to finish my salad. Sorry, guys. Salad is delicious. I love it. My wife made it for me. I think we might. Let's see if anybody else is still up and handling court. Trisham's gone. Never seen this one before. Oops, let's go back to it. Where it's like a spy camera in the ceiling vent.
The court is on the record in City of Conneaut versus Daniel Anderson, case number 24 CRB 325. On October 22nd, 2024, Mr. Anderson pled not guilty to one count of assault, a first-degree misdemeanor. We conducted a first pretrial conference on November 19th, 2024, and today we are scheduled for a second pretrial conference. Mr. Anderson is in the courtroom. He's accompanied by his attorney, William Bobalski. Also present is Law Director John Lewis. The court is recording this proceeding by way of video, utilizing whereby.com. I did grant the alleged victim, Robert Levinson, the chance to participate at this hearing by way of video. And Mr. Levinson, I think Mr. Levinson is there. Mr. Levinson is present. Okay. The court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. Your Honor, prior to going on the record, I spoke to Mr. Levinson via whereby, and I believe we've come to a resolution of the case today, should the court be willing to accept it. Based on my conversation with Mr. Levinson, the city would amend the assault charge to an aggravated disorderly conduct under Ordinance 509.03. A1E3A, that is a fourth-degree misdemeanor. With a plea to that charge, Your Honor, the city would recommend probation, whatever fine the court would deem appropriate, along with the court costs of the case. Again, I spoke to Mr. Robert Levinson, the alleged victim. He is in agreement. He did not have any out-of-pocket expense at all as a result of this, and he is on board with the resolution. Thank you.
Thank you. Mr. Bobalski.
Your Honor, Mr. Lewis has described the agreement that
has been entered into. We have asked, and I have presented to Mr. Lewis my request that this be a plea of no contest, simply because of the issues of potential civil claims. And we are prepared, though, to proceed, and we will not be contesting any part of the charge as amended, Your Honor.
Thank you. Mr. Levinson, you heard Mr. Lewis, the law director or prosecutor, outline the terms of the proposed resolution. Did you understand his proposal?
I understood the law director's proposal, yes. I did not understand the no contest aspect of the
wow, coming in
gentleman
hot.
representing the defendant.
Okay. Mr. Lewis, when discussing the matter with Mr. Levinson, did you talk about a no contest?
Your Honor, I did not discuss that with Mr. Levinson because it hadn't been brought up yet by Mr. Popolski. But on behalf of the city, I have no objection to a no contest plea.
Well, I don't think it's the court's purview to explain what a no contest plea is to the victim before I take a plea here. So, you know, I think he has a right to know what a no contest plea is, and I think it's not the court's obligation, more or less, to explain to him what a no contest plea is. So would you like time to talk to him about that?
Certainly, Your Honor.
Okay. So,
Judge,
Mr. Levinson,
I'm not gonna explain
you raise a very good point. I'm going to recess for a brief time to allow Mr. Lewis to explain to you what this means, okay?
Okay, thank you.
Thank you. So we'll go off the record. Thank you.
That was fun. Fun little court. Quick hit there. Just visiting briefly. Well, he explains no contest and what that means. No contest when they're saying, look, we have enough, there's enough evidence you could find me guilty. A jury could convict me. I'm not going to fight that, but I'm also not going to admit that I do it. Because if I admit that I do it, then I could be civilly liable to a greater degree than maybe I am right now. Let's see what else we have. I don't see anybody else. I've been dredging the bottom of the true crime world, looking for stuff for you guys, and I'm just not seeing. Thurston's done. We might be done for today, guys. I don't know what else to tell you. Lunch was good. Salad was delicious, although I need to clean my desk now because I spilled some dressing on it. I feel like it was in a steam bath. Yeah, that camera. A little humid up there at the top of the room there. Check the burner. Will do. Dan, I haven't checked that one. I'll keep an eye on that. Might pop in there. But let me tell you what I have to do this afternoon. I realize some of you guys are going to be watching football, Red Pen. Their kickoff's like happening right now. But I've got to prep for the show that we're doing tomorrow afternoon. With all the nominations, we're trying to find videos. We're going to play clips of some of the things that happened. We're going to relive the moment, so to speak. So I'm going to be working on that and building a document that I can work off of. And then tomorrow we are doing our end of year. Let's see. Okay, I'm taking a look at Mod Chat. Tomorrow we're doing our end of year thing, which Mod Chat is about. So we'll call. I'll talk to the mods here right after this, if that works. So that means we'll take a break. You guys can go to lunch. I'm going to go to work. I'll talk with the mods right now. Oh, that's not it. Wait. There we go. That's the right one. We ran out of crimes and criminals. Shouldn't that be a good thing? It's good. Although we're just making it for a bigger day on Tuesday or on Thursday. Tomorrow will be awesome. Plan on it. We're going to have a lot of fun. Bad Beats, thank you very much. Appreciate it. Thanks for all your generosity. Thanks for all the gifted memberships today. You guys are amazing. Congratulations on all the milestones as well. Love seeing those roll in. Can you still submit something for tomorrow? You might have to text it to the burner, but we've got like 90 some odd submissions right now. We'll see. Not all of them are going to make it, I can tell you that. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. I'm trying to get out of my chair here. Tomorrow morning's when we go live again next. Desk is coming to me. Just wait for it. There we go. I'm going to stop shopping for lapidary polishing equipment and go to work, I promise. All right. We're done for the day. We're done for the day. You guys have a good one. I'm not sure who to send you to. I'm looking. I just can't see anybody. How about Grizzly True Crime? Ooh, the Grizzly True Crime. Guys, we'll see you later. See you tomorrow. Bye-bye.